That's why without the number it can't be listed. Now you have number agide Monday bharat.
My lord,
I've already given a date on Monday. Nimdalla, yours. I've already given a date on Monday. Why are you moving it again? Another memo in the same matter? Then what is that? May not be able to reach it on Monday now. Correct. Monday barli bidi. Yav stage allar barli. Monday barli. Yes.
my lord. Relay BDA matter, my lord.
Give it, sir. Give the memos.
Preliminary hearing, number 1.
But why no what?
Lordship,
Hmm.
I am appealing for the petitioner.
Hmm.
Petitioner challenged the order passed by the First Assistant Assistant Commissioner
Ah,
in under Senior Citizen Act.
all right.
Lordship, may kindly see petitioners are the children of first wife
Hmm.
and third respondent is the second wife of second respondent.
Second wife of second respondent.
Second wife is the third respondent of second respondent.
Irli bidi heli.
Here, Lordship, may kindly see, it is a purely an ex parte order
Hmm.
passed by the Assistant Commissioner.
Where is the order?
He has asked her to pay 5 lakhs as a maintenance charges and another 5 lakhs.
Where is the order?
It is at page Annex A, my lordship.
Page.
Page 27, appropriate pay order is at 26, my lords.
All right. One moment.
26. Shall I read, my lordship?
Yes, sir. You don't need to read. 5 lakhs is what is awarded to be collected
Yes.
from the tenants lessees within 15 days.
And 5 lakhs from tenants. The tenants are giving rent to only the second respondent, father of the petitioners. They never taken any rent from anybody. Even the all rent agreement stands
Hmm.
in the name of second respondent, their father.
Whose property is that?
Properties belong to first wife. We have filed a partition suit, my lordship.
Hmm.
Partition suit is pending
Hmm.
and the honorable trial court has passed a status quo. Both the parties to maintain status quo until disposal of the suit.
Hmm.
Lordship, may kindly see the order sheet, my lordship. I have produced the order sheet.
You are not heard in the matter?
I have not at all. Kindly see page 88, my lords, Annex H.
1 minute. Where is
Annex
it?
H.
You are the
Yes, appropriate portion
which
is that
respondents? All the respondents, huh?
all the respond. Kindly see 89, my lordship.
1 minute.
ಪ್ರಕರಣದ ಮರುವಿಚಾರಣೆಗೆ ದಿನಾಂಕ ನಿಗದಿಪಡಿಸೋಕೆ ಕಡತ ಮಂಡಿಸಿದೆ. ಪ್ರಕರಣ ಆರಳಿ ಕಾಯ್ಸ ಟ್ರಾನ್ಸ್ಫರ್ ಬಂದರು ಆರ್ಡರ್ಸ್ ಹಾಕೊಂಡು ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರು.
ಒಂದೇ ನಿಮಿಷ.
The new assistant.
Wait, sir.
Page 89, my lordship.
Wait, sir.
There is no date also mentioned, my lordship. ಪ್ರಕರಣ ಮರುವಿಚಾರಣೆ ವಿಚಾರಣಾ ದಿನಾಂಕ ಡ್ಯಾಶಕ್ಕೆ ಗೊತ್ತುಪಡಿಸಿ ಪ್ರತಿಗಳಿಗೆ ತಿಳುವಳಿಕೆ ನೀಡಲು ಕೋರಲಾಗಿದೆ. ಏನು ತಿಳುವಳಿಕೆ ನೋಟಿಸು ಇಲ್ಲ. The new officer who assumed charge has passed an order without giving any opportunity to the petitioners. Hello. I have
1
not.
minute. I'll come back.
I have not submitted.
Wait. Mostly, sir. Finish, ಮಾಡಿ.
Lordship, I have also filed objections to the petition. Objections to his writ petition, my lordship.
Objections to writ petition.
Hello, sorry, synopsis, synopsis
Oh.
I have filed.
That's okay. ಈಗ ಆಯ್ತು.
He has filed an application for vacating interim order.
Correct.
For that, I have filed objections.
So what?
Lordship, may kindly see in the objection statement I produced.
Hmm. Hmm.
Para 11, kindly come to para 11, my lordship. Page 4 of my counter objections to the application.
Now you tell me what is wrong with this order. You said you are not heard. I will hear him.
Yes.
Next ground.
Section 9 of the act is very clear.
10,000 rupees. ಮಾತ್ರ
10,000
ಕೊಡ್ಬೇಕು.
rupees.
All right. Next ground.
Next ground is the properties belong to mother and the suit is pending before the trial court. Trial court has already passed an order to maintain status quo. Now evidence is going on. There we have produced lot of documents. It's a property belongs to mother and is into undivided family. She by forcibly got gifted.
How did it come to you now?
They came by gifted, was from first wife, forcibly they have taken.
Forcibly taken.
Forcibly, she has died of giving poison. Mother, first wife was died, they are given poison, second wife, and also this petition is filed on the instigation of second respondent and children. Kindly see the photographs are produced. The second wife children
ಪರವಾಗಿಲ್ಲ. ಗ್ರೌಂಡ್ಸ್ ಹೇಳಿ ಅಂದ್ರೆ ಫೋಟೋಗ್ರಾಫ್ ಹೋಗ್ತದೆ.
ಎಲ್ಲ ಬಂದು ಒಡೆದು ಬಾಕ್ಲೆಲ್ಲ ಇದ್ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ.
ಇವತ್ತು ತುಂಬಾ ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾರಿಗೆ?
ಪೆಟಿಷನರ್ಸ್ಗೆ. And the suit is also pending. This honorable court, there are a lot of decisions in liking that. When the suit is pending before the trial court, even honorable high court has no power to when there is a dispute regarding property, that cannot disposes me from thee, because it's into undivided family.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೂ ಪವರ್ ಇಲ್ಲ ಅಂತ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ ಸ್ವಾಮಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ.
ಆಮೇಲೆ
ಹೇಳಿದೆ. ಮತ್ತೆ I have produced the synopsis, my lords. Kindly come to synopsis.
Grounds ಹೇಳಿ ಅಂದ್ರೆ synopsis ಹೋಗ್ತಾರೆ.
Grounds there is, it is purely an expert order. I produced the photographs. ಹೇಗೆ ಬಂದು ಅವ್ರು ಹೊಡೆದಾಕಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ನಾವೇ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅದು ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ಗೆ ಏನ್ ಸಂಬಂಧ?
ಅಲ್ಲಲ್ಲ, ಈಗ ಪೊಲೀಸ್ನ ಕರ್ಕೊಂಡ್ ಅವ್ರು ಬಂದು ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್, ದಿ ಸೆಕೆಂಡ್ ಸನ್ ಈಸ್ ಆಲ್ಸೋ ಗೆಟಿಂಗ್ 5 lakh salary. He is also software engineer, and the second daughter of second wife is also working. She is getting handsome salary.
Handsome salary.
Yes.
Handsome salary.
And now, under the instigation of second wife and children, the respondent number 2 has filed this petition. And the assistant commissioner, without the order sheet, barely clears that. Without giving any opportunity. Maro notice kodi indro, notice kodlilla enu illa. He assumed charge and passed an order that he has not any power to grant 5 lakhs, since the act itself, section 9 says 10,000. And he has also said 5 lakhs rent. We are not receiving. We have produced before the trial court. All lease agreement stands in the name of the second respondent. All the leaseholders are paying to only second respondent. The children are not taking any single pie from the building. Nearly more than 1,25,000 rent they are getting from the building, my lordship. And also earlier, the sons of the first wife are jointly working with father in the automobile industry. The statement of accounts produced in the trial court, I have also brought statement account. All amount was drawn by the second respondent, nearly more than lakhs together, under the which has been earned by the joint family. The petitioners are not at all disturbed the father, only under the instigation of the second wife and children. They have filed the writ petition, this petition before the assistant commissioner. I produced the documents in with synopsis, my lords.
All right. Yes, sir. 88. Respondent is present, hence the matter is posted for orders. ಆಯ್ತು, ಆಮೇಲೆ where is the gift deed? My name under who are you? Who bequeathed the property to you?
Initially, the property was purchased by father in the name of first wife and second wife. Thereafter, the first wife had some years. She had written a will in 1996. 1996 she died. Thereafter 97, the father transferred in the name of 50% of her share was transferred in the name of father. So 96 father stood in the name of respondent number 2 and 3. And thereafter 97,
Hmm.
they have taken loan and they have constructed the building.
Hmm.
Now after 30 years, they say it is and thereafter your chief is statement. After transfer 96 on also after stamping.
Hmm.
That's what I'm saying. They have
ಗಿಫ್ಟ್ ಡೀಡ್ ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
gift deed ಮಾಡಿ will
ಯಾರಿಗ್ ಮಾಡಿದೀರಾ?
first wife
Hmm.
big paper of the husband.
ಅದಾಯ್ತು, ಇವ್ರಿಗೆ ಹೆಂಗ್ ಬಂತು
In our forcefully entered 2017 they have entered forcefully.
entered forcefully ಅಂದ್ರೆ you were in possession of the building.
We were in possession of the premises. We were collecting the rent from the ground floor. 2017 they forcefully entered. They dispossessed us. Thereafter we are staying in rent here. Now we are staying in rent.
Now they are in possession of the property.
Second and third floor of the premises. They are running PG1.
All
They are
right.
not allowing me to enter.
Huh.
I have constructed to see that during my giving this, I give this. So they are not allowing.
1 minute. You said give, one ನಿಮಿಷ, ಗಿಫ್ಟ್ ಡೀಡ್ ಇದೆ ಅಂದ್ರಲ್ಲ ಯಾವ್ದು?
ಅಲ್ಲ ವಿಲ್, ಸಾರಿ ಮೈ ಅಪಾಲಜಿ, ವಿಲ್ ಮಾಡಿದ ಸಮ್ ಗಿಫ್ಟ್.
ಒಂದ್ ನಿಮಿಷ, ನಿಮಗೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್?
ವಿಲ್ ನಮ್ಗೆ ಅವ್ರ ಮದರ್ ಕೊಟ್ಟಿದ್ದ ಪ್ರಾಪರ್ಟಿ ಅದು, ಗೋಲ್ಡ್ ಎಲ್ಲ ತಂದು ಹಾಕಿ ಮಾಡಿ ಅವ್ರಿಗೆ ಮದರ್ ಹೆಸರಿಗೆ ಬಂದಿದೆ.
On what right are you in that property now?
Because property stands in the mother, in the name of mother.
Which mother?
And
ಈಗ ವಿಲ್ ಅವ್ರ ಹೆಸರಲ್ಲಿ
first wife.
ಒಂದ್ ನಿಮಿಷ, ವಿಲ್ was in the property is in the name of the husband.
No, first property stands in the name of wife, not husband.
ವಿಲ್ ಯಾರಿಗೆ ಮಾಡಿದ್ದಾರೆ ಸರ್?
ವಿಲ್ ಅವರೇ ಫೋರ್ಸ್ಫುಲಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದು ಅವ್ರ ಗಂಡನ ಹೆಸರಿಗೆ.
ಒಟ್ಟಲ್ಲಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ತಾನೆ?
ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಫೋರ್ಸ್ಫುಲಿ, because all disputes are before the.
ಒಂದ್ ನಿಮಿಷ,
That's partition suit ಅಲ್ಲಿ ಎಲ್ಲ ಇದೆ.
sir.
Serious disputes ಇದೆ.
Wait, how did you drive that person away from the house?
We are not at or since from date they are living in the house, since from whatever they are now just living.
On what document have you occupied the property?
Lordship joint automobiles ಇತ್ತು ಬೋರಾ, ಎಲ್ಲರೂ ಇವ್ರ ಮಕ್ಕಳೆಲ್ಲ ಅಲ್ಲೇ ಇದ್ರು. ಇವರು ವೈಫ್ ಸೆಕೆಂಡ್ ಮದುವೆ ಆದ್ಮೇಲೆ they want to reside in the separate
Where
house.
is the copy of the will?
ಒಂದ್ ನಿಮಿಷ ಸ್ವಾಮಿ, ಒಂದ್ ನಿಮಿಷ.
ಒಂದ್ ನಿಮಿಷ ಇರಿ. Where is the copy of the will? ಇದೆ ಇಲ್ಲಿ. Where is the schedule here? What is the immovable property? House ಏನದು? Half share of that, is it?
It was purchased in first wife and second wife. Why did it recommend?
So you're in ಮಿಕ್ಕಿದ half share ಯಾರಿಗೆ? ಅವರಿಗೆ. ಆಯ್ತು. ಈಗ they are the children of the second wife. First wife. First wife is the one who bequeathed the property in the name of the husband. Now, so you're saying your children have driven you out.
Even the second wife was also teacher. She also had income. So she has also contributed. But 27 is the loan document.
So according to you, they were heard, they were served, they were heard, first thing. And there is no document of gift or whatever in their favor, but. Yes.
Page number 27 is the document. So when I have
ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಹೇಳಿದಿರಲ್ಲ, ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಹೇಳಿದಿರ ಎಲ್ಲ. ಪೆನ್ ಡ್ರೈವ್ ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ? ಪೆನ್ ಡ್ರೈವ್ ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ?
Pen drive, when I, based on the entry model of this report, when this on entry model says that I can enter the premises, they should not restrain me.
Oh, they have further restrained.
When I visited the premises, they restrained me. So that, video, sir.
Lordship, kindly
Wait sir, ಅವ್ರು ಮುಗ್ದಿಲ್ಲ ಇನ್ನು.
Here is senior citizen.
ಯಾಕೆ ಇಲ್ವಾ?
Arrest to the court.
Senior.
ಅವರಲ್ಲ ಮೈಕ್ ತಗೊಂಬನ್ನಿ ಅಂತ ಹೇಳಿ.
Yes, ma'am. This is the clear case where a senior citizen has been harassed, my lord. The object of Senior Citizenship Act itself is that, my lord, speedy justice to the senior citizen. Now already they have dragged for 7 years, my lord.
ಓ,
Lord,
ಯಾವ 7 years?
in 2017 I had, they have driven me. 2019 I have, not
2007
here, my lord, sorry. Ali 2019 in the, I have been.
All right. Yes sir.
For my lord.
Lordship, the Hindu undivided family.
Hindu and
Here also
senior
they are
citizen
using-
act
One more,
ಮಾಡ್ತೀರಾ
one more,
ಬೇರೆ
my lord.
ಏನಲ್ಲ.
1 minute, some.
Wait.
I am staying in the
Wait
rented
sir,
accommodation.
ಆಯ್ತು, wait, yes.
Lordship, kindly see, I am producing the statement of account, even for construction, the sons have paid the money every date of.
97 they were
since
10
from
years, my lord.
99.
ಅಲ್ಲ 99 they were
ಒಂದ್
10 years
ನಿಮಿಷ
only.
sir.
Sorry.
ಸ್ವಾಮಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ,
ಹಾ.
ಇವತ್ತು ಮತ್ತೆ ತರಿಸಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಹಾ,
He
ಸರಿ.
has drawn nearly 40,000, the second respondent, to pay the loan
So,
amount.
he's your father?
Yes, because, see, the second
He's
wife,
your father?
yes, we have taken to his house, photos ಎಲ್ಲ ಇದೆ, ಕಾಫಿ ಕುಡಿ ಇವ್ರು ಬಿಡದಿಲ್ಲ ಅಲ್ಲಿ ಬರಕ್ ಅವರು. The wife and children's not ಅವ್ರು ಬಿಡದಿ ಡೈರೆಕ್ಟ್ ಮಾಡಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ, ಫೋಟೋ ತೋರಿಸಿ ನೋಡಿ
One
ಸ್ವಾಮಿ.
minute, 1 minute. So, ಈಗ he's your father.
ಎಸ್,
ಬಿಡ್ತಾ ನೀವು ಒಳಗ್ ನಿಮ್ ಮನೆಗ್ ಬರ್ತಾ ಇಲ್ವಾ ಅವರು?
ನಾವು ಕರ್ಕೊಂಡು ಹೋಗಿ ಫೋಟೋಸ್ ಹಾಕಿ
ಒಂದ್ ನಿಮಿಷ.
ತಿಂಡಿ ಕಾಫಿ ಕೊಟ್ಟು ಎಲ್ಲ
ಕಾಫಿ ಕೊಟ್ಟ?
ಮನೆಗಿರಿ ಅಂತಲೂ ಹೇಳಿದೀವಿ, ಅವ್ರು ಬಿಡದಿಲ್ಲ ಇರೋದಕ್ಕೆ.
ಒಂದ್ ನಿಮಿಷ.
ದೇ ಆರ್ ಅವಾಯ್ಡಿಂಗ್.
ಈಗೇನ್ ಹೇಳಿದ್ರಿ? ಮನೇಲಿ ಇರಿ ಅಂತ ಹೇಳಿದ್ರೆ ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ಅವ್ರು ಇರ್ಲಿಲ್ಲ. So it is admitted that you have entered the house and he is out of the house, correct? How did you enter the house?
ಎರಡನೇ ಹೆಂಡತಿ ಮಗ ಸುತ್ತಿಗೆ ತಗೊಂಡು ಹೊಡಿತಾ ಇರೋದು ನೋಡಿ, ಫೋಟೋಸ್ ಆರ್ ಪ್ರೊಡ್ಯೂಸ್ ವಿತ್ ದಿ ಸಿನಾಪ್ಸಿಸ್.
All right.
ಹೂ ಆರ್ ಡೂಯಿಂಗ್ ಕ್ರಿಮಿನಲ್ ಆಕ್ಟ್. ದಿ ಒಬ್ಬ ಮಗ
ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ವಾ?
We have lodged complaint, but they have not taken action.
ಪೊಲೀಸ್ ಕೇಮ್ ಅಂಡ್ ಸೀನ್, ಅವನೇ ಬಂದು ಹೊಡೆದಾಕ್ತಿರೋದು, ಅವರೇ ಬಂದು ಗಲಾಟೆ ಮಾಡಿದ್ ನೋಡಿ ಅಡ್ವೈಸ್ ಮಾಡಿ ಕಳ್ಸಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ನಮ್ಮ ಮನೆ
ಪೊಲೀಸ್ ಅಡ್ವೈಸ್?
ಪೊಲೀಸರು ಬಂದು ಅವ್ರಿಗೆ ಅಡ್ವೈಸ್ ಮಾಡಿ ಕಳ್ಸಿದ್ದಾರೆ.
ಮಾಡೋದು ಶುರು ಮಾಡಿದ್ದೀರಾ?
ಪೊಲೀಸ್ ಕೇಮ್, ಪೊಲೀಸ್ ಕಮ್ ಟು ದಿ ಸ್ಪಾಟ್, ಅವರು ನಾವೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ವಿ. ಕೈಂಡ್ಲಿ ಸಿ ಸ್ವಾಮಿ, ಫಸ್ಟ್ AC ಆರ್ಡರ್ ಅಲ್ಲಿ 5/1/21 ಆರ್ಡರ್ ಆಗಿಲ್ಲ. He has been transferred.
ಪರವಾಗಿಲ್ಲ, that I will answer. Don't
It is purely exported and one
No
decision,
problem. No
one decision ಸ್ವಾಮಿ.
I thought you were on gift deed. Gift ಇಲ್ಲ ಏನೂ ಇಲ್ಲ ಇಲ್ಲಿ. Yes.
ಅಲ್ಲ, ಒಂದು ಡಿಸಿಷನ್ ಸ್ವಾಮಿ.
ಕೊಡಿ, ಎರಡು ಕೊಡಿ, ಅದೇ ಒಂದೇ.
Power of tribunal to direct handing over possession of a property. The power and jurisdiction of the tribunal is restricted to grant.
Why are you relying on this? According to you, you are not in possession of the property.
We are in possession.
How did you get into the property?
We are living there. We are having ration card. We are having phone.
It stands in the name of the father. How are you saying that, staying
This
there?
giant family property. How can it thrown out? We are doing business jointly.
That is why you can throw out the father.
We are not at all thrown out from me. 2005 ಅವರು ನೋಡಿ, how many plenty of properties are produced, sale deeds. He is having also another. I produce along with my edition. Crores of property stands in the name of the father.
An interim order not heard ಅಂತ ಕೊಟ್ರದ?
it was heard and posted.
Even in the civil court granted interim order status not to dispose me from the property.
Not to precipitate ಅಷ್ಟೇ.
Not to precipitate ಅಂತ ಅಷ್ಟೇ. Undertaking on the basis of undertaking.
You gave an undertaking.
How
sir.
they are.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸಸ್ ಮಾಡಬಾರದು ಅಂತ ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ, ಅಂಟಿಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ದಿ ಪಾರ್ಟಿಷನ್ ಸೂಟ್.
All
ಐ
right.
ಪ್ರೊಡ್ಯೂಸ್ so many
No problem.
crores of ಪ್ರಾಪರ್ಟಿ ಇದೆ ಸ್ವಾಮಿ ಅವರ ಹೆಸರಲ್ಲಿ.
Crores of property.
ಹೌದು, ಐ ಪ್ರೊಡ್ಯೂಸ್ ಸೇಲ್ ಡೀಡ್ಸ್ and also property.
Crores worth property, sir.
Crores
Crores of
worth-
property.
crores worth properties, and also the wives of second children are also liable to caretake of the father. They are also getting more than 5 lakhs, but the son of the second wife. And here they intentionally, with the instigation of wife and daughter and son of the second wife, they are all doing these things, my lordship. Yeah, therefore the trial court has passed an order not to dispossess me until disposal of the partition. Partition suit is pending.
ಆಯ್ತು. Yes. Heard reserved.
Much. Produce some judgments, my lord.
ನೋಡಿ ಯಾವ ಜಡ್ಮೆಂಟ್ ಇದೆ?
Along with the synopsis.
ಹಾ
of the-
ಗೊತ್ತಾಯ್ತು. Yes.
Much of.
Yes, next.
Number 2,
My lords, I appear for the petitioner, my lords. In serial number 2. My lords, the matter was sought to be mediated, my lords.
Infructuous, sir.
No, my lords, it is not infructuous.
Then there is an
There's a submission made by the caveator counsel, but it is not infructuous, my lords.
now what is the matter now?
My lords, the matter is as against the rejection of an order 7 rule 11.
All right,
The matter was sought to be mediated, my lords, between the parties, and the mediation has failed.
all right.
My lords, we have to report the mediation failed to the division bench of this honorable high court.
Division bench wise?
My lords, in a separate proceedings, my lords, they had impugned certain actions of the KIADB,
All
as
right,
against which the matter ended up before the division bench.
all right.
And in the division bench, both parties sought to mediate the disputes arising in the civil suit.
Hmm.
Now, the parties went into mediation.
We had
And-
given an undertaking before the division bench, Manoj, that he won't precipitate any of the matters while the mediation process is
The
under.
mediation process is on?
It has failed.
No,
but
it has failed, right?
It has failed,
It is
my lords, but we have to report before the honorable division
That's
bench. that
okay.
please vacate it.
Where is the order of the division bench?
Manoj, I don't, you have it?
ಕೊಡಿ. So it is still the mediation,
I'm sorry, Manoj.
till the mediation.
Till
not
the
to
mediation,
precipitate.
my lords.
Now mediation has failed.
Mediation has failed, my lords. We just require 2 weeks' time. We'll report it to the division bench and we'll be back before this.
The learned counsel appearing for the petitioner and the respondent. The parties to the list are also before the division bench in
Writ appeal number-
writ appeal 1770 of 2024.
1772,
Two, my
Manoj.
lords.
177?
Two, my
Two,
lords.
my lords.
2 of 2024,
Please.
wherein the parties were directed to mediate between themselves to steer clear the controversy. To enable such mediation, the division bench has directed the parties not to precipitate the matter in any litigation pending between them. The learned counsel for the petitioner submits that the mediation now has failed and the same is required to be reported to the division bench. In that light, list the matter on 4th July. Yes.
Manoj, may I please speak for the 7th or 8th, Manoj? An arbitration on the 4th, Manoj.
Then 4th July.
Manoj, please, Manoj, 7th. If,
4th July.
Right.
You should have told something else.
no, Manoj,
4th July, yes.
Manoj, I will not be in Bangalore, that's why, Manoj. It's not-
Arbitration, yes.
Please, before Justice Gunjal, Manoj, it's just,
So,
no, Manoj, it just got adjourned yesterday to that date. I cannot seek for that to be set aside, please.
yes,
Manoj,
list
7th,
on
7th or 8th. if possible.
11th July.
Please, Manoj, I'm grateful.
3,
Sorry, your lordship, with your lordship's leave, Kalburgi bench high court. Serial item number 3, your lordship.
Yes, yes, we'll take it later, wait.
All right, that respect.
Please, Madam. So in this matter, my lord, the suit for partition, a compromise has been entered between the plaintiffs and the defendants. Final decree has also been drawn. These scheduled properties are the properties which are allotted to the share of the petitioner herein, my lord.
Mm.
Subsequent to the decree, my lord, final decree has also been drawn and the matter was sent for registration.
Mm.
Then what's happened is the sub-registrar, since the POD was required to be done,
Mm.
the sub-registrar refused to register the,
What is the amendment carried out?
my lord, amendment sought for is that only sub-numbers are required to be added, my lord. To the same properties, there's no change in the schedule or the identity of the property, my lord.
That is
Ah.
rejected.
Please, my lord.
Page 4 of the writ petition, please. The properties allotted to the petitioner is mentioned at page 4 of the writ petition. The
Huh.
original survey number was 100. The total extent was 3 acres.
Huh.
in which
Now-
he was allotted with 1 acre 20 guntas.
Hmm.
Now that is reported as 100/1.
Reported as
100/1.
100,
That one.
all right.
So for that reasons, all the 5 schedules has been reported as whatever the property allotted to the petitioners.
Also produce the OD copies and sketch
You are
copies.
also supporting him.
Please.
There's no dispute between the parties now.
ಈ ಪೋಡಿ ಆಗಿರೋದನ್ನ you want-
ಪೋಡಿ ಆಗಿರೋದನ್ನ ಇನ್ಕಾರ್ಪೊರೇಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ.
Where is the impugned order?
At annexure M, my lord, page 93, my lord. The court holds that since the court has become functus officio and it's not a typographical error or a clerical error.
So when did the Hisar Podi take place?
Please, produce the copies of the podium. That's subsequent to the final decree, ma'am.
Suit is 2013.
Please, ma'am.
Decree ಆಗಿದೆ ಯಾವಾಗ?
Decree, I also produce the decree copy, ma'am.
Date ಹೇಳಿ sir.
Please, ma'am.
To the compromise.
On 7/1/2014, ma'am.
ಪೋಡಿ ಆಗಿದೆ ಯಾವಾಗ?
Podi agit subsequent agi, it's on 9/9/2022, ma'am.
Yes, allowed.
Please, ma'am.
Much.
Much.
Next.
4,
ನಾನು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೆ. ನಾನು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೆ.
My lord, this is National Highway authorities have notified to acquire certain extent of land. The land between this
ಅಷ್ಟೇನಾ?
the Talaguppa, Marthu to Talaguppa. This is the road they want to make bypass. This is under challenge. Now, my lord, this road was in use since 1915. It is a straight road. In the year 1977, the road has been upgraded as state highway. And in the year 1995, it has been upgraded as a national highway. At the time of
Where
upgrade,
is your initial objection to the preliminary notification?
we have filed it, my lord.
Where is
We
it?
have filed it. I have not annexed it because as on the
No,
date,
no, I want to see if you are objecting throughout from then.
we objected that all those things, I can produce it. Even on the last date also, I made a submission. This Honorable Court passed a detailed order on 24,
Page.
24/1/2025.
This proceeding itself?
In this proceedings, my lord. And 24/1/2025.
One moment. ಏನಾಗಿದೆ report? Where is the report? With the report?
Entire report is 27 to February 2022 itself. Report is filed.
After the report, it has not come before the court, is it?
No, last occasion it has come, my lord, it
Ah,
was
where-
posted from the
What is the report?
office notification. But, we have submitted
No, this coordinate bench has directed you to explore the possibilities or feasibility to expand the road.
41.
Sketch.
Yes. Three options have been 41. Three options have been suggested. One is at the first number, option number 1, 2, 3. The second one is what they are now contending. Now the option what we are executing is option number 1. The third option is towards the after railway station. That is it's coming.
ಈಗ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಯಾವ ರೋಡ್ ಸರ್ ನೀವು ಹೇಳ್ತೀರಾ ಸ್ಕೆಚ್ ಅಲ್ಲಿ?
Now to discuss what they are contending.
ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಯಾವ ರೋಡ್ ಇದೆ?
Road number 2, gas.
In my sketch, my lord, this is at annexed.
ಇಲ್ಲ ಪೇಜ್ 41 ಗೆ ಬನ್ನಿ.
Page 41 of my.
ಸ್ಕೆಚ್ ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಬನ್ನಿ. ಈಗ ರಿಅಲೈನ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
Realignment is not possible because Three options,
41
what are the difficulties? The second option, what they are pretending, that road can be used, cannot be used because that's the maximum speed what we can conveniently form is only 50 kilometers. And the crossroads are many. Inside that is the red mark in between.
ನೀವು ರೆಫರ್ ಮಾಡ್ತೀರಾ ರೋಡ್ ಯಾವ್ದು ಸರ್?
Mine is 29 annexure E, my lord, in my red picture.
ಈ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಇಲ್ವಾ?
ಈ sketch ಅಲ್ಲಿ ಇದೆ, ನಾನು ಕಲರ್ ಹಾಕಿದ್ದೇನೆ for clarity and easy understanding, my lord.
Annexure A.
Annexure E at page number 29.
All right. Same. Yes.
Same.
ಹೇಳಿ.
Now the existing road, I have marked it in yellow. My lord got it.
All right.
Now the bypass, they want to make it this red or purple color I have made it.
ಈಗ ಆಲ್ಟರ್ನೇಟ್ ರೂಟ್ ಮಾಡ್ಕೊಟ್ರೆ ಅವರು?
My lord?
ಆಲ್ಟರ್ನೇಟ್ ರೂಟ್ ಮಾಡ್ಕೊಟ್ರೆ?
ಅಲ್ಲ, ಆಲ್ಟರ್ನೇಟ್ ರೋಡ್ ಅಲ್ಲ, ಇಲ್ಲಿ ಆಗಿರೋದು ಇಲ್ಲಿ ರೆವಿನ್ಯೂ ಆಫೀಸರ್ಸ್ ಆಮೇಲೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ಯಾಕಂದ್ರೆ 45 meters or 75 feet all along it was vacant. Now because of some change of political situation in the taluka and district, they allowed all these persons to put up a thatched roof. I have also produced a few photographs to show that in the existing railway station, existing government hospital, existing this Gram Panchayat office, and all these offices are behind the boundary of 45 meters from the center of the road. But these persons, for the past 2-3 years, they have put up all these unauthorized sheds, and now they are saying that the commercial establishment has been established. I have produced several photographs to evidence that these are the photographs
that have come up in the last 3 years.
Recently, what is the action taken by the deputy commissioner or the panchayat officers, my lord? They have allowed them. Now they want this potential and very fertile lands. These are all the lands which the tenants have got it in Kagudu moment, where the tenancy has been granted. They're all 1 acre, 1.5 acre, 2 acre. They're all fully irrigated lands, paddy fields and arcanite plantations. Now these they want to divert it because of local reason. These persons, the huts they are.
Where is the reason objections line ಹೇಳ್ತೀರಾ?
My lord,
Comment.
may I kindly take 1 or 2 few photographs, my lord? On these things there is no comments by these persons.
ಏನು ಹೇಳಿಲ್ವಾ?
ಏನು ಹೇಳಿಲ್ಲ. ಆಮೇಲೆ ಎರಡನೇದಾಗಿ ಇವ್ರು ಹಾಕಿರೋ ಅಬ್ಜೆಕ್ಷನ್ ನನಗೆ ಸ್ವಲ್ಪ ಕಾಲಾವಕಾಶ ಕೊಟ್ಟರೆ ನಾನು ಕೌಂಟರ್ ಹಾಕ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೀನಿ. ಇದೆ ಉದ್ದಕ್ಕೂ ಈ ಒಂದು ಟೆಂಪ್ರರಿ ಆಗಿ ಕಟ್ಟಿರುವಂತ ಶೀಟ್ ಮನೆಗಳು ಇಲ್ಲ ಹೆಂಚಿನ ಮನೆಗಳು ಹಾಕೊಂಡಿದ್ದಾರೆ. ಎಕ್ಸಿಸ್ಟಿಂಗ್
ಈಗ ವಾಟ್ ಇಸ್ ದಿಸ್ ಏರಿಯಾ?
ಇದೆ 45 meters ನಲ್ಲಿರುವಂತ ನ್ಯಾಷನಲ್ ಹೈವೇ ಅಥಾರಿಟೀಸ್ ದೇ ಡಿಮಾರ್ಕೆಟೆಡ್ ಇನ್ ದ ಇಯರ್ 1885. In that boundary line, these are the.
ಇದನ್ನ ತೆಗ್ಸಿಲ್ವಾ ನೀವು?
ಅದನ್ನ ತೆಗ್ಸ್ತೀರಾ?
One or two like that it is there.
These are admittedly unauthorized constructions. What and you are going into that road when you have ಇದನ್ನ ತೆಗೆದ್ರೆ ಇದೇ ರೋಡ್ ಆಗುತ್ತೆ? Yes sir.
It will not be. Page number 41.
What it will not be?
Page number 27 itself may be turned. There are 3 options. Feasibility reports was being submitted before to the national.
3 options to save the road?
To form the road. Save the road is a different one as that of the form the road. I will explain the options.
ಈಗ ಇದನ್ನ you remove all this.
That we will do, madam. Any argument first that we will do.
ಆದ್ಮೇಲೆ.
The existing railway station, existing government.
I will say that with respect to railway station also.
Existing library, it is behind 45 meters. I have submitted copies to them also.
Yes sir.
41, page 41, the feasibility report. Which every feasibility report is outsourced to a third party. Third party will give the feasibility report after obtaining all the revenue documents and the feasibility report. The option number 1 at page number 41 itself has one color, or else page number 27. Option number 1 is 3.2 kilometers. Option number 1 is 3.2 kilometers. 3 kilometers. Option number 2, what they are asking to clear up the entire mess of about 3.18 kilometers. 3.18 kilometers. And the option number 3 is 3.45 kilometers. That is 3.4 kilometers. In option number 1, we will get a plain land wherein we can travel. There are houses also. We are paying the compensation for them also. The details of the compensation, what we are paying and what the award has already been passed These are been produced for this honorable court. We record in objection at page number 82 maybe.
Right, please.
81 and 82.
We'll take it on Tuesday in plenary hearing.
And further, this.
Stay there, intermodal ಇದೆಯಲ್ಲ.
ಇದೆ entry ಮಾಡಿರೋದು. To be extended.
ರೋಡ್ ಫಾರ್ಮ್ ಆಗಿದೆ. ಇಲ್ಲಿ 3.2 kilometers ಆಫ್ ರೋಡ್ is left over. ಬೈಪಾಸ್ ಮಾಡಿದ್ರೆ ಆಪ್ಷನ್ ಏನಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಈ ಕಡೆ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ is also going for further railway station is also formed. Means ready for extension. And we get a railway crossing about one railway crossing at that junction, and we have to also ask for the railway railway department for crossing that road in the city, mid of the city.
Tuesday,
Please.
in the same state.
These are the construction in 2023
Look into it.
and 22. No license, no authority, obligement. Interim to be continued.
That is a different one of clearing the road, madam. That may be, that he can urge, but option of three options.
Right, we'll see.
5,
Interim order to be continued.
Intermodal subsisting will continue to the next.
Obligement.
Lord, I am appearing for appellant, my lord.
Only this.
Lord.
The challenge before your lordship is, my lord, the annexure, L, my lord, in page number 179. This compromise petition came to be filed before the lower appellate court. And lower appellate court has deferred this matter, accepting the compromise. Compromise petition accepted, but it is not decreed. Kindly see, my lord, the sale deed in respect of suit schedule item number 5 and 9, which is executed in favor of the petitioner as per annexure A in page number 18, that is sale deed dated 8/12/2015 by one Muniappa and his family. There are two sale deeds, my lord, that is annexure A and B, which we have produced. These two sale deeds has been executed in respect of two items, my lord. Then, my lord, the one Gaurama, the Muniappa and his family executed by virtue of a partition deed dated 2011. Then one Gaurama, sister of Muniappa, has filed suit in page number 51, OS number 49 of 2014. My lord, she sought partition and also she sought cancellation of sale deed executed in my favor. Decree, my lord, your lordship would get in page number 79, my lord.
Which is the RFA pending?
RFA, my lord, is pending, which is, my lord, the decree which is challenged. Decree passed by the trial court has been challenged by Muniappa, who has sold it to us, and he has accepted in the before the trial court. Kindly see RFA copy that we have produced before this court. The RFA, my lord.
Now you have got the property.
Yes.
Or somebody sold the property to you on the strength of that compromise.
No.
Then.
On the strength of the partition deed which they have entered, and Muniappa has executed sale deed in 5.
Partition is entered in what, which OS?
Partition OS number 49, my lord.
49 of 2014.
Yes.
What happened to the RA?
RA, my lord, that I have challenged in respect of item number 5 and 9. And, my lord, the Muniappa who has sold in item number 5 and 9 has filed, my lord, RFA before this honorable court, challenging the decree as against Gaurama. Subsequent to that, Gaurama and entire defendants, they have come before this court and compromise petition has been entered.
Now what did you ask before?
I have asked, my lord, insofar as item number 5 and 9, compromise decree can be passed. Kindly see the RFA order. The RFA, even RFA decree also, I will not affect. RFA, my lord, allowed also that Gaurama has filed partition.
File an application in the RFA and take it.
Kindly.
RFA is pending, sir.
RFA pending. Kindly for a moment, my lord, kindly see RFA. And compromise petition which you have filed. RFA, my lord, they themselves have sought. Kindly see RFA, my lord, page number 131.
You have no objection?
I have no objection.
For what?
Lord, for allowing the petition for this reason, my lord. One branch of family, my lord, the Muniappa branch.
Who are the other contesting respondents?
All the contesting respondents have entered into
compromise.
The first branch of the family had sold this property. The other branch had filed the suit for partition.
Now what is pending in the RFA?
My lord, there were 11 properties. Out of that, only 2 properties is what it is compromised. With respect to other properties, the Muniappa's family, the person who had executed the sale deed, my lord, they said that the partition is not valid and it is their
That
property.
is, that is
And
subject matter of
pending
RFA.
That is,
The properties that he is holding is not subject matter of RFA?
no, that is not, my lord.
Where do I get it?
Kindly take, my lord, decree also. Kindly page number 80, my lord.
80.
80. That is judgment.
And my lord, that Muniappa has admitted that he has sold in favor of me.
Lord, page number 80. Lord, the fourth, the sale deed executed, Lord, with respect to, in favor of defendant number 13 and 14, in respect of item number 5 and 9, is not binding on share of plaintiff and defendant number 2 to 7. Muniappa is defendant number 1 who had executed sale deed, who has filed RFA now. So, my lord, that was even binding on him, even as per the judgment in the partition suit.
Why does the court reject it now then?
Court rejected only RFA pending consideration before this court.
Defendants and so on.
It is for that reason, my lord, last date of hearing, RFA was connected. They said no objection, and thereafter it got disconnected, my lord.
RFA was connected to this.
RFA was
Connected,
connected
last
for, date of hearing, it was there. They had no objection, but it was interstate dispute between them.
Even RFA allowed also, my compromise will not affect.
We'll see. We'll take it on Monday. I will also go through it. List on Monday.
I have produced RFA copy also before this court.
I will see. Yes. Next.
Present petitioner, for weeks time to
Respondent
take
number
steps
1.
in respect of respondent number.
Last time we made a submission, the respondent number 2 was placed ex parte, he is the tenant. So it may not be necessary, he has undertaken to file a memo seeking dispensation.
To take steps in respect of respondent number 2, who is in occupation of the premises.
All right. A week's time is granted to do the needful. Yes. Interim order in
Illa.
Next.
7.
I appear for the petitioner. This is the application I made for police protection.
My lords, I have no case. I am aware
Police
of
protection.
Police protection. Temporary injunction is granted. And there is also a judgment of this court saying that once injunction is granted, police protection has to be granted. My difficulty is this. I have challenged the temporary injunction order by way of an appeal. And I made an application, I made an application to advance the matter for hearing. And we have placed our arguments on merits. Court insisted me to argue on merits.
That's all right. But if he has a TI, he is entitled to.
I'm aware of it. My lords, we have advanced our arguments on 11/6/2025 on merits. Court has heard substantial. And he made a request to get an adjournment to give a, to place his argument. That is on 25/6/2025.
May I make one request?
How does that stop from granting police?
Because we are in, my lords, ultimately it has to be decided on merits. My lords, now my difficulty is that.
There is an injunction in his favor.
Definitely, my lords, I am aware of it. My difficulty.
In accordance with the circular 14/11/2018, they will grant.
My difficulty is this, my lords. By taking advantage of the police protection order, they will dispossess me.
No, I will observe that but dispossession will not, he is in possession and TI court.
The finding is there. But my difficulty is that taking advantage of the police protection order, they will dispossess me.
Whatever, I will just direct police protection to be granted in terms of.
Well, still 25/6, can I make a request for an adjournment?
No.
My lords, at his request, the matter was adjourned. My lords, kindly see the status of the case.
Our argument.
Trial court.
My
lords, we pressed for an interim order for a stay of the injunction order. Court has said that you place your arguments on merits. We advanced our argument and matter was posted for his reply argument.
Police protection is rejected, is it?
That is rejected. That is rejected.
That is why I filed this petition.
Till 25/6/2025 is my request.
All right, list the matter on 27th.
If at all the MA.
In the event no order would come about, this court would consider the case on its merit. Yes. 27th. Yes, next. Police ke salpa id madidre possession dispose maadbidtare. Yes.
I appear for the petitioner.
Police protection.
I appear for the petitioner. my
Yes,
lord.
sir.
This is a case, my lord, where the plaintiff had filed a suit. I'm the defendant number 2 in the commercial court. Plaintiff had filed a suit for recovery. The case is a concept of, my lord, subcontracting. I am defendant number 2. I have certain works to be executed. I engage the services of defendant number 1. Defendant number 1 in turn engages the services of the plaintiff. There is no privity of contract between me and the plaintiff. The plaintiff in his plaint has averred, my lord may kindly take.
What is the order under challenge?
The deletion application has been rejected.
Your deletion application.
Please, my lord. I had filed it on the ground that there is no privity of contract.
Suit commercial was instituted by whom?
The respondent number 1, defendant, plaintiff.
And the contract is between?
Plaintiff and defendant number
For
1.
one.
Respondent number 2, who was deleted because he's placed ex parte before the commercial court as well. My lord may kindly take up.
No, different, respondent number 2 is placed ex parte.
I'll placed ex parte.
Sorry. Illi you want to get yourself deleted.
Please.
Plaintiff ಏನ್ ಮಾಡ್ತಾರೆ ಆಮೇಲೆ?
He can secure an ex parte order against defendant number 1 and proceed. He is himself admitted that nandenu illa.
Where is the privity of contract?
Please see, my lord, page 5, paragraph 5, page 25.
Paragraph 5.
I'm looking at the plaint, my lord. Para 5 alli, page 25 alli, plaint. It is submitted, if I may read. It is submitted that in spite of time given by the plaintiff, the defendant number 1 was postponing payment by giving excuses, even though defendant number 1 was assuring to make payment time and again through email messages, but nothing was done by defendant number 1 to clear the dues. Due to attitude of defendant number 1 and failure to discharge their liabilities, even though the bill was settled by defendant number 2 to defendant number 1 in respect of the contract work completed on so and so, plaintiff have suffered loss. Idu heli, then our plaintiff defendant number 1 kotti checks bounce agide anta heltare. Then para 10 may be seen, my lord. Para 10, page 26 alli, it is submitted that plaintiffs have arranged to send a legal notice dated so and so calling upon defendant number 1.
The court rejected your application.
The court rejected my application, my lord. That my lord will find at 109. 109 alli, it's a lengthy para. Kelgadeinda 12ನೇ line. That on perusal of the pleadings and contentions. Kelgadeinda 12ನೇ line. One point is clear, the defendant 2 had entrusted work to defendant 1. In turn, he has entrusted the work in favor of plaintiff. So plaintiff has executed the work. According to him, the bill has not been settled by defendant 1 and raising objection on so and so. The real question involved of the case is in respect of settlement of bill pertaining to work executed by the plaintiff is related to defendant number 2. He might have settled the bill in favor of defendant 1. Since plaintiff claims he is entitled for said amount, for adjudication I am responsible. They themselves admit that I have already repaid. Nothing remains to be, my lord, adjudicated with respect to me.
Yes. Serve on the plaintiff.
I have served. They have entered appearance, my lord.
Nobody is here.
Moorne disa, their third time they are not appearing before the court.
Just a moment.
They have entered appearance. Mr. Mahalinga has entered appearance.
Petitioner to yaar appear ಆಗ್ತಿದ್ದಾರೆ?
Mahalinga Bhatt anta
Heard the learned counsel appearing for the petitioner. There is no representation on behalf of the first respondent. The petitioner is before the court against an order of the concerned court which rejects the application filed by the petitioner under Order 1 Rule 10(2) of the CPC seeking his deletion from the array of defendants. The learned counsel submits that there is no contract between the plaintiff and the present defendant, as the contract was between the defendant number 1 and the plaintiff. The work was entrusted to defendant number 1 and the execution of the work is by defendant number 1 and the contract is also between plaintiff and defendant number 1. Prima facie, the court, prima facie, the order that is called in question is erroneous. In that light, further proceedings, what do you further proceedings?
My lord?
Further proceedings before the concerned court.
Commercial OS 297 of 24.
Shall remain stayed till the next date of hearing. List on 3rd.
I'm great.
2nd July. Yes,
grateful.
9.
Preparing for petitioner. Kindly short passover, my lord, after
Short
preliminary.
ಇವತ್ತು ಯಾವ passover?
After preliminary hearing.
Again,
Senior is held up in other.
what's the matter?
I have engaged the senior counsel in Lord.
For the plaintiff, ex parte order of temporary injunction is granted.
Who is the plaintiff?
I am the plaintiff, my lord, sir.
I am
It is
not
by
made
the
a party, my lord,
party
where
who is not a party.
allegations are made against me in the plaintiff.
Yenidu?
Ex parte order mele, or they could have filed an application there, either to implicate themselves or, my lord, and for vacating. But instead they want to prosecute this. I have no, instead of pass over, if they want time, my lord, their lordships can have.
No, but I pass over.
Because it had come up before vacation also. It's not first time it's coming up.
Vacation bench.
They took
Vacation
time, my lord,
ಮುಂಚೆಯಿಂದ
twice.
ಬಂದು ಹೋಗ್ತಾ ಇದೆ.
They took time, my lord,
I
twice.
did not take time,
Okay,
please.
ask your colleagues.
Only in
Ask the
vacation
colleague.
bench.
It is, my lord. it's-
Vacation
that
bench ಅಲ್ಲಿ
took time.
ತಗೊಂಡಿರೋದು.
I have not.
Before
I
vacation,
have
2525 it came.
it's on vacation bench. Before that it had
Your
come.
original records, oh, records are called here.
Yes, called.
You are not a party?
I am not a party before the trial court. Where, my lord, in the prayer as well as in the entire pleadings, the allegations are against me.
Pass over. I'll take it at 12:30. Next.
10,
In this matter, my lord, SG Egide, my lord, advocate for the Kivet, is out of station because his father-in-law is hospital. That may be called on Monday or Tuesday.
On which day?
Tuesday.
Again, emergency.
Urgency, my lord. Today it is the case is there, my lord.
For what?
For further class of the PW.
What are you challenging?
My lord, I am challenging the appointment of commissioner rejected the application, holding that it amounts to collecting of evidence, despite there being a direction by the Sam court, my lord.
Where is that? Direction of this court, Kodi first.
Please, my lord. Page number 167, my lord. Paragraph 9, my lord. My lord, earlier I have challenged the order.
First paragraph 9.
Paragraph 9, my lord.
Ah.
Yes, the writ petition lacks of merit and same is day. However, it is open for the plaintiff to file application seeking appointment of commissioner for local instrument to find out the structures that existing as the suitable property. If such application is filed, the trial court shall consider the application in the light of the evidence adduced before it, and if it feels necessary, to appoint commissioner and to proceed in accordance with law, my lord. Now the my lord again, my lord, rejected the application. Your lordship can return to page number under page number 227, my lord. So 228 is the operative portion of the order, my lord. But when the said evidence is read with the plaintiff averments on the 8 line bit. But when the said evidence is read with the plaintiff, there is no pleading to that effect in such circumstances.
Para 8, 166.
Right. The writ petition I'll order it.
How this?
Please, madam. The application filed by the plaintiff seeking appointment of local inspection to find out who is in possession of the suitable property. This could not have been allowed or could not have been permitted by the trial court, as a outcome cannot be appointed to collection of evidence. More particularly in respect of the matter which the trial court had decided based on evidence adduced before. Therefore, there is no error in the committed by the trial court in rejecting the application. Yes, the writ petition lacks of merit and same is dismissed. However, it is open for the plaintiff.
Petitioner was before this court calling in writ petition 31217 of 2024, calling in question an order passed by the concerned court dated 16/11/2024 in OS 100 of 2023, rejecting an application filed by the petitioner and order 26 rule 9 seeking appointment of the commissioner. While dismissing the challenge, the coordinate bench is observed as follows: 167. Liberty was reserved to the petitioner to file an application seeking appointment of a commissioner to find out the structures that exist in the suit schedule property. The application should have merited, at least to the extent that this court had observed, coordinate bench of this court had observed as quoted supra. The application is now rejected without considering even the observation made by this court. In that light, further proceedings before the concerned court shall remain stayed till the next date of hearing. List on 20th. List on 23rd.
Appear for the petitioner.
The petitioner challenged the order passed, the petitioner is the plaintiff before the trial court. The plaintiff petitioner filed a suit for bail injunction initially, but during the pendency of the suit, my lord, the defendant respondent.
Order 26 rule 9.
Please, ma'am.
Order 26 rule 9.
Please, madam. Application was allowed and commissioner was appointed, madam. Thereafter, madam, the plaintiff with the petitioner has not filed any objection. The defendant, the respondent herein filed an objection, took a specific contention. There is a procedure lapse on the part of the commissioner to submit the report. And he had cross-examination also, madam. Thereafter, I filed an application to requesting the trial judge to pass an order regarding acceptance or rejection of the commissioner report, madam. That application came to be disposed of, holding that the commissioner report will be considered at the time of merits of the case, madam.
Application filed only with respect to acceptance of commissioner report.
Acceptance or otherwise, I filed an application.
Yes, sir. Anything else?
Madam, my submission is that, madam,
it will take note of at the time necessary.
As per section order 10, madam, order 26 rule 10(3), madam, if the court come to conclusion that, madam, the commissioner report is not in accordance with law, madam, the court has to consider once again for issuance of the fresh commissioner report.
Don't do it.
But in the event since the
nothing is done now. What is done now? It is held, present case needs to be considered along with available materials, oral and documentary, placed on record by both the parties, along with the merits of the case.
If it is court come to conclusion that, the commission report is not in accordance with law, then, as per
ಅದು ಬಂದಾಗ ನೋಡೋಣ.
Final judgment ಗೆ ಅಂತ ಹಾಕೊಂಡಿರ್ತಾರೆ ಸ್ವಾಮಿ.
ಎಲ್ಲ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ, next ಅದಕ್ಕೆ merits of the case ಅಂದಾಗ final judgment ಗೆ.
That will see. ಅದು ಹಾಕ್ದಾಗ ನೋಡಿ. If no order is passed on this, you tell me. This does not call for interference. Yes. Anything else, sir?
The judgments of the honorable Supreme Court.
ಯಾವುದಕ್ಕೆ ಈ ತರ ಮಾಡಬಾರ್ದು ಅಂತನಾ?
Before that, my lord, they have to consider.
Where the plaintiff?
Please, my lord.
ಕೊಡಿ.
Sorry, my lord. One of the.
Stay ಮಾಡಿದ್ರೆ ನಿಮಗೆ ತೊಂದರೆ ಅಲ್ಲ. Stay ಮಾಡಿದ್ರೆ ನಿಮಗೆ ತೊಂದರೆ.
ಅಲ್ಲ, ನನಗೆ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ಲಿ ಅಂತ ಸ್ವಾಮಿ. ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ಲಿ, then I am ready to argue the matter. Because.
ಕೊಡಿ, judgment ಕೊಡಿ.
Sorry, I have only one copy of the coordinate bench of this honorable court.
ಷಡಾಕ್ಷರಪ್ಪನ. ಷಡಾಕ್ಷರಪ್ಪ.
Please, my lord. Actually, where they hold. ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. Before that passing, after they heard the matter on commissioner report, the court required to pass an order, a relevant portions.
No, page 21, my lord, it will be considered based on the available documents, material evidence placed by the parties to this.
Direct further inquiry depending upon the facts, matter of caution, it is clarified.
A relevant portion, I fold it, sorry, ma'am.
Proper procedure. Anything else?
And one more Supreme Court judgments. Relevant portion in page number 18 and para 18 and 20, your lordship. An appropriate answer to the questions aforesaid is not for the to seek in a para 18. In a case course of the civil court by way of incidental proceedings, the court could issue a commission inter-alia for making local investigation as per section 75 CPC. The procedure in relation to such commission for the local investigation is specified rule 9 and 10 of order 26 of the court. This suffice, it is noticed that in present purpose that as per class 3 rule 10 of 26, the way the court is dissatisfied with the proceedings of such a local commission, it could direct such proceeding further inquiry to be made as considered fit. But in the Indian scales also, my lord, the learned, the honorable High Court of my lord, rejected the appeal solely on the ground that the commission report is not in accordance with law. And
so that is not the order now.
Now, my lord, in that event, my lord, I have to ಮತ್ತೆ ಅದು judgment alone challenge ಮಾಡಬೇಕಾಗುತ್ತೆ, appeal ಹಾಕಬೇಕಾಗುತ್ತೆ. Therefore, I request, because there is a procedure under the order 26 rule 10(3), my lord, they have to pass an order. If the order is passed, my lord, the court may accept, may not be accept, my lord. I am not coming the way of that, my lord, but I requested the court to consider the court commissioner report first, my lord. Let the court may proceed.
Yes.
Para 20 also, my lord. In that case, also honorable Supreme Court.
Sandesh.
My lord, since it is a mere suit, bare suit for injunction, whatever the findings recorded by the trial court is that, my lord, based on the available materials available on record, my lord, and the person who is in
this doesn't call for interference.
Para 20 of the Supreme Court judgment, my lord, where the Supreme Court appointed the phrase and remitted the matter.
See, if the report of the commissioner was suffering from irregularity, then a fresh report had to be called for. There is nothing now. Even later it can be called for if there
ಅಲ್ಲ
is an
ಸ್ವಾಮಿ
irregularity.
ಅದೇನಾಗಿದೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೇಳಿದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಹೋಗಿರುತ್ತೆ, ಅಕಸ್ಮಾತ್ ಅವ್ರ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಸೂಟ್ ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
Judgment ಹೋದಾಗ ಬನ್ನಿ.
ಅಲ್ಲ ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡುವಾಗ್ಲೇ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿರೋದು.
Considered along with documentary evidence placed on record by both the parties.
ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ, ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಆಗಿ ಇಟ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗ್ದಿದೆ, ಈಗ ನನ್ನ ರಿಪ್ಲೈ ಅಷ್ಟೇ ಕೊಡೋದಿದೆ.
No sir.
No, no, my lord.
This does not call for any interference.
My lord, my anxiety is that, my lord, in the event, the court come to conclusion that there is a procedure irregularity in submitting the court commission report. Since the matter is, ನಾನು argument ಮಾಡಿದ್ರೆ judgment ಗೆ ಹೋಗುತ್ತೆ ಸ್ವಾಮಿ. Judgment ಅಲ್ಲಿ ಅವರು
ಕನ್ಸಿಡರ್ ಮಾಡದೇನೆ ಜಡ್ಜ್ಮೆಂಟ್ ಹೋದ್ರೆ ಅವಾಗ ಹೇಳಿ.
ಅಲ್ಲ ಈಗ ಆಲ್ರೆಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಕೇಳಿ
ಜಡ್ಜ್ಮೆಂಟ್ ಹೋದ್ರೆ ಬನ್ನಿ. While reserve liberty to approach the court.
With that observation.
Yes, yes. The petitioner is before this court calling in question an order passed on order 26 rule 10 adu
rule
order,
ಇಲ್ಲ
rule 9
151 ಕೆಳಗಡೆ application
passed on application filed by the petitioner seeking acceptance or rejection of the report of the commissioner. The order that is passed by the concerned court is as follows. After detailed discussion with regard to the appointment of the commissioner for the purpose of identification of the property, the concerned court passes an order holding that on the evidence and available material, the commissioner's report would be considered along with the merit of the matter. The learned counsel is before this court on the contention that the matter would be posted for its judgment without looking into the commissioner's report.
Argument ಕೇಳಿದ ತಕ್ಷಣ ಹಾಕೋಬಹುದು.
Without looking into the commissioner's without considering whether the commissioner's report is correct or otherwise. Therefore, serious prejudice would ensue to the petitioner. The submission is noted only to be rejected as the court has not passed any order finding a defect in the commissioner's report and has only considered that it would be noted while considering the case on its merit. Therefore, if in the event the matter is posted for judgment without passing an order in the commissioner's report, the petitioner is at liberty to approach this court in approach the appropriate fora in appropriate proceedings.
Oblige.
Yes, with the aforesaid observation, petition stands disposed.
Oblige.
Next again, page 82. The order passed by the Bank Development Authority. Wherein the Kata.
Restoration of Kata.
See, Allah, it was standing in my name. They set us cancel.
Covered under otherwise.
Cancelled the Kata holding that. Respondent number 4 filed an application for Kata. Saying that.
Who is R4?
Respondent 4 is the.
Bank.
Howdo. Plainly see the order passed by the BDA, page 82, last paragraph.
Why did the bank come into picture?
Bank said my vendor has obtained the loan from the bank. They want a e-Kata for auction the property. They want to auction the property.
HCGP is directed to accept notice for respondent 1, 2 and 3. Yeah. Huh? Oh, BDL. 1 BDA yardralla. Ajay Kumar is directed to accept notice for respondent 2 and 3. Petitioner to serve set of papers upon the aforesaid counsel. The TP Muttanala, Madam, Canara Bank. Learned counsel TP Muttanna is directed to accept notice for the 4th respondent. Petitioner to serve set of papers upon the aforesaid counsel as well. The petitioner calls in question an order of the 2nd respondent dated 29/5/2025 by which the Kata that stood in the name of the petitioner is now transposed to that of the name of the 4th respondent Canara Bank on the score that the petitioner's vendor's vendor had availed a loan on the property that is now in possession of the petitioner. In the light of the said, the prima facie, the order of the BDA, the prima facie, the order of the BDA is, appears to be erroneous. In that light, there shall be an interim order of stay of the order dated 25/9/2025 and all other proceedings.
29.
29/5.
25.
25/9 29/5/2025. Yes.
Not for NTL.
ಅದೇನ ಅರ್ಜೆನ್ಸಿ?
ಇಲ್ಲಿ ಅವರಿಗೆ ಈ ಖಾತಾ ಕೊಟ್ಬಿಟ್ಟು ಆಕ್ಷನ್ ತೆಗಿತಾರೆ.
ತಗೊಳ್ಳಿ. ಎಸ್. ನೀವು ಬಾರೋವರ್ ಅವರಿಂದ ತಗೊಂಡಿದ್ದೆ ಯಾವಾಗ?
ನಾನು ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ಇಸ್ ಇನ್ ದ 2013.
2013.
ಫಸ್ಟ್ BDA ಇಂದ ರಿಲೀಸ್ ಆಗಿದ್ದು ನಾನು ವೆಂಡರ್ಗೆ 2013. ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ವಾಸ್ ಇನ್ 2017. My sale deed is in 2023.
Yes. Next.
13.
Petitioner. My lord, petitioner is the dependent in a suit for partition, is the sole dependent. He is infirm, not able to walk. Therefore, my lord, with the support of the medical certificate, which is found at annexure E, annexure E, he requests the court to appoint a court commissioner, that is under Order 26, Rule 1. My lord,
Suit for what?
Suit for partition between me and my brothers and sisters. My lord, that application came to be rejected. The operative portion is at ink page 51, my lord. The court says, in the medical certificate, kindly see page 51, my lord, second paragraph. Above said provision makes it clear that the court should accept the certificate issued by registered medical practitioner as.
Who is the contesting respondent?
My lord, I am the contesting defendant.
Sorry.
Yes.
Plaintiff petitioner shall serve on the counsel to represent the plaintiffs before the concerned court and file an acknowledgement in the next 4 days. List the matter on 27th. Till such time, further proceedings before the concerned court shall remain stayed.
Obliged.
Next.
For the petitioner's concerns. My lord, without passing an award, they are trying to take possession of the property. The direction by this honorable court, my lords will see at page 25.
You are in possession?
I'm in possession.
This under the act, Lord. First position will be taken.
Amel award. Amel award.
Award. That is the procedure act.
This land will consider. Don't dispose them till the next day.
Last of kindly say, order of this honorable court, annexure A, only direction to consider. The first they have to approach the Tahsildar because this is a government land. This honorable court directed to Tahsildar to first consider request for entering Kata. Thereafter, he has to approach the KADB for that. That has not happened still today. Without that, it's a premature, my lord. It's not maintainable.
They will do it, but don't dispose them. They will do all that.
You will also call section provisions of the act, my lord. Section 28, my lord. 28. And he is not the notified Katadar also still.
Yes. Your name is not entered in the records now?
Not at.
My lord, there is an order passed by the DC, my lords, directing it to be entered. Despite that it is not entered, I have made a representation on 4th of April. Sir, that representation, my lords, will find at annexure K1 at page 81, requesting them to enter my name. My lords, my name is not there in the RTC for a few years. It was there before it was computerized. That is found in the order itself. My lords may see.
What did the DC do?
My lords, the DC found that the Saguvalli chit was granted to me in 1974 itself.
All right. DC directs entry of the name?
Yes, DC directs entry.
Where is that order?
My lords, the order, my lords, starts at page annexure G, page 64, my lords. May I request, my lord, to kindly see page 66.
66, sir.
Yes, my lords. Annexure G, page 66. Annexure G starts at.
Tahsildar Yelahanka to ascertain the position and tally action. If any mismatch, continue the revenue entry in respect of the land, measuring so and so in favor of the respondent here. Who was the respondent? Who is the respondent?
My lords, I was the respondent. Iraka. I am the respondent.
What has the Tahsildar done after this? This is 4th March 25.
24.
24,
my lords. Tahsildar does not do anything, my lords. I file a writ petition because, my lord, the land is notified by the KADB. My lords will find the writ petition order, my lords, at page 22. If I may just read from para 4. Para
That
four-
now what is the problem?
My lords, the problem today, my lords, is that till date they had not taken possession.
Hmm.
We were prosecuting with the Tahsildar. Now,
Hmm.
my lords, my name is not shown in the RTC for a few years. Remaining years they have shown, I've produced the paper. Now they are coming to precipitate the matter and take possession of the property without passing over. Insofar as the contention of my learned friend that first possession will be taken and thereafter compensation will be paid, my lords, that, my lords, is not correct. My lords, insofar as the possession and this thing is concerned, my lords, may kindly see.
We'll consider that. No problem. Heard the learned counsel Ajay Nandalake appearing for the petitioner and PV Chandrasekhar representing the board as well as the state. What is the Tahsildar doing?
To verify, my lord,
Huh?
the entries can't be done in
DCS,
his name. Only for
DCS
the-
directed a particular action to be done a year ago. What is it done?
Only for taking the.
Whatever,
Yes.
sir, what has he done?
Yes, not like that.
The petitioner is before the court apprehending precipitation of taking of possession of the property from the hands by the KIDB on acquisition. The petitioner ಅಲ್ಲಿ ಇವ್ರ ಮುಂದೆ ಹೋಗಿದ್ಯಾರು DC ಮುಂದೆ?
Nane Swami. I only had gone.
Government. Anyway.
Grievance is only for payment of compensation.
1 minute, yes. The proceedings were before the deputy commissioner. The deputy commissioner, in terms of his order dated 4th March 2024, directs the revenue entry in respect of the property to be continued in favor of the respondent and directs the Tahsildar to ascertain the position and tally the RTC in column 3 and 9 if there is any mismatch. This direction to the Tahsildar has gone to the winds, as the Tahsildar, as on today, has not done anything. The petitioner had to approach this court in writ petition 9466 of 2025. The coordinate bench disposed the petition by the following order. Even then, the Tahsildar has not passed any order. Now the KIDB wants to take possession of the property without payment of compensation. More so on the score that the name of the petitioner does not figure in the RTC. Therefore, the very claim of compensation would become bleak. In that light, the what is the stay entry order short for?
My lords, precipitative action including taking possession.
Yes, there shall be an interim order as prayed for till the next date of hearing. Yes, sir.
We are permitted to file objections.
Madi, sir.
Liberty ಎಲ್ಲ ನಾವು ಕೇಳ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Liberty is reserved to the respondent board to either to seek vacation of the interim order or file statement of objections as the case would be.
Section 28 ತಗೊಂಡ್ ಸರ್ ನೋಡ್ಬಿಟ್ರೆ ಕನೆಕ್ಷನ್.
ಅವ ನೋಡೋಣ. Yes.
15.
ಇಲ್ಲ, ಈ shall also not improve, ಮೇಲೆ. We shall also not improve the constructions ಮಾಡ್ತಾರೆ.
You also don't precipitate.
Then you will occupy, say.
Both the parties shall maintain status quo, pay the property till the next date.
I didn't follow what my learned friend said.
No, you also should not construct anything.
My lords, I'll give an undertaking. Status quo ಅಂತ ಹೇಳಿದ್ರೆ then they will say we are in possession ಹಂಗಂತ. I'll give an undertaking right now.
The learned counsel for the petitioner undertakes that he would not put up any construction in the property. Next.
15.
Petitioner. I will
From
permit to
yesterday.
take notice. Order sheet ಅಲ್ಲಿ ಬರ್ಲಿಲ್ಲ. Notice ತಗೊಂಡು.
ನಿಮ್ಮ ಹೆಸರ?
ಬಂದಿಲ್ಲ ನೋಟಿಸ್. ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದು.
ಅಲ್ಲ, ನೋಟಿಸ್ ಅಂತ ಮಾಡ್ಬಿಡಿ ಫಸ್ಟ್, ಆಮೇಲೆ. Yes. Text notice ಅಂತ. Yes.
Yes, my lords.
Yesterday's matter.
Yesterday's matter.
Yesterday's matter.
Yes.
My lords, the petitioners before your lordships are the defendants in the original suit, where a preliminary decree is passed in respect of the partition, my lords. That judgment and decree has reached finality, and final decree proceedings were initiated in FDP 8 of 2019-90, my lords. And the FDP court allows the petition and it directs 1/6 share to be divided amongst the parties, my lords. The extent of land, for example, my lords, your lordship will turn to page 20, where I have raised a appeal against the final decree proceedings in RA number 40 of 2024, my lords.
in para 5, I have stated, my lord, how this is impracticable to divide the property by meets and bounds to the extent of 1/6 share, because in survey number 4/2, last para, page number 2, my lords, half a gunta is there. That half a gunta has to be divided into 6 portions. Then another 6.5 gunta is there. That also to be divided into 1/6 share. I filed appeal. Appeal is pending consideration. There is a delay of 39 days in filing the appeal, my lords. I have filed an application for continuation of delay. The final, this RA appeal, my lords, appellate court conducted inquiry also on my delay application instead of allowing that application, my lords. It did not concluded. Then I filed an application saying that the plaintiff has filed the execution petition before the court, and the execution court has passed an order to issue delivery warrant, my lords. That is at, your lordship may kindly peruse this.
Suit is of the year 1990.
1991.
1981.
And my lords, my appeal is.
What is the date of the decree? Preliminary decree?
Preliminary decree is 2023. 1990. Nobody questioned, my lord.
10/1988.
1988. Nobody questioned that preliminary. Even the petitioners before your lordship have not. FDP was initiated in the year 1990, my lords. FDP was allowed. Then we called in question in appeal, my lords. In filing the appeal, there is delay of 39 days. That 39 days delay was not condoned, and the application was kept pending. They filed objections, inquiry was held. They did not address the arguments. I addressed the arguments also. It went on adjourning from time to time. In the meantime, they filed execution petition to execute the final decree, my lords. The final decree court has passed an order for issue of delivery warrant. Your lordship will find at page 60. Issue delivery warrant directing the JDR number 1 to 6 to hand over possession of the property as per final decree proceedings. Await report. I have called in question this order for this reason, my lords. My application for stay is pending before the RA, and my application has been thereafter disposed of by an order dated 3rd May 2025, my lords. My application rejected. The stay application is rejected on the premise that my delay application is not yet considered, so I cannot consider this present application without condoning the delay. The appeal court kept the matter pending for 1.5 years in respect of condonation of delay application. We brought to the notice of the executing court. Executing court says that unless you have a stay, I cannot stop it.
Unless you have a
stay in the appeal.
Yes, sir.
And my appeal becomes infructuous if they take delivery. And they have filed application for police help. Today is the hearing date.
Yes, Gangarappa sir.
Decree is dated 26/10/1988. Suit for partition has been decreed. More than 37
It
years.
is understandable, but what about this?
None, in fact, a commissioner was appointed for effecting partition.
Correct.
Of the parties. Report was submitted by the commissioner. None of the parties filed objection to the report of the commissioner. It has been accepted. Final decree has been passed. Therefore, I am entitled to take my possession of the property which I am entitled to as per the decree. Nobody filed objection to the report of the commissioner, nor objected regarding the passing.
So what is the appeal now filed in RA 40 of 24?
They have filed the appeal against the final decree order. After drawing up of the final decree.
Final decree of.
Final decree has been passed and final decree has already been drawn. I have filed the execution.
Then what is this 39 days delay? Only 39 days?
In filing the appeal. After the final decree.
Itself is not
sir,
maintainable.
appeal is challenging the FDP.
Yes.
Right.
FDP is dated what? Decree, final decree yavat agiradu?
18/123. 18/123.
Yes, but ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಮಾತ್ರ ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಮಾಡಿದ್ರೆ ಅಂತಂದ್ರೆ ಆರ್ಡರ್ 41 rule 3 is a bar. Without continuation of delay, appellate.
No, that is correct.
Yes.
You keep the petition pending for 1 year on continuation of delay and then reject it and give out everything.
No, I quite see, but they did not cooperate with the court in passing the order.
Hello, that's all right. ಈಗ you tell me 39 days delay ಇದೆ. ಒಂದು ವರ್ಷದಲ್ಲಿ ಕಂಡೋನ್ ಮಾಡ್ಬಿಟ್ಟು he could have passed some order on merits.
That could have been done. That could have been done.
Yes.
I'm not.
No, I
disputing
understand
about
suit is that old, but court also should pass
No,
appropriate
I
orders.
wanted to submit before the court. They are not giving property to anybody else. I am entitled to as a sharer. How long I can?
That is on
my
the
my, my
that is
major
on the-
portion of my life
No,
has
no, that
already
is on
been
the
spent
merit
in
of
the
the
court.
matter. The court now says, because delay is not condoned, I will not grant stay.
That is-
Delay is not condoned because of the act of the court itself.
No, no, it's not the act of the court. It is on account of non-cooperation.
No.
I think
Respondent.
ಯಾರಿಂದಾರು
They did
ಆಗ್ಬೋದು.
not.
ಅಲ್ಲ, ಅದು ಯಾರಿಂದಾರು ಆಗ್ಬೋದು. ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಮಾಡ್ಬೇಕು ತಾನೆ.
ಅಲ್ಲ delay condemnation ಮಾಡೋದು ಬಿಡೋದು it is the discretion of the court.
Correct.
Yes.
ಅದಾದ್ರೆ that order should be passed.
That is true, but I am not coming in the way of the court
Till
passing any
ಒಂದು
order.
ವಾರದಲ್ಲಿ we will direct the court to consider that
No, my submission
application
before
for
the honorable
condonation of
court is,
delay ಮಾಡ್ಲಿ.
in the execution proceedings, there is already an order to deliver possession of the property as per the final decree. I am entitled to take delivery of the possession in case I will submit before the court. In case they succeed in the appeal or the final decree is set aside, restitution could be ordered. There is no
Why
difficulty.
all that?
Yeah.
ಈಗ
No.
preliminary stage ಅಲ್ಲಿ
No.
condonation of, I will direct the court to pass an order on the condonation of delay application
my
and then
submission-
reconsider this.
My submission is this. Only twofold I am making submission. Number one is on account of their not cooperating the court.
That is wrong.
Yes, that is the
Right,
position.
sir.
Anyway,
All right.
not cooperating in getting the application disposed of, court has taken its own time. There are so many other reasons also on account of transfer of the presiding officer.
Whatever.
I'm not, anyway. Now, major portion of my life has been spent in the court in getting the decree
I only-
and realization of the fruits of the
Only
decree.
1 week I am granting to the court to pass orders on the application seeking condonation of delay. ಮತ್ತೆ I will fix a date for everything.
I would like to submit this way. Let the matter be pending. In case delivery of possession has
Now,
already
he has
taken.
already rejected the application on the ground that delay is not condoned. For the action of the court, why should the application be rejected? Courts could have passed.
For the
earlier.
inaction of the appellants, why the respondent to be punished? That is the
See,
incidental question that would arise.
Something should be done in accordance with law. Now, I will grant a week's time, let the court pass an order on the delay application and consider this application later.
My submission is appeal before the appellate court challenging the final decree passed is not maintainable because they did not file any objection to the report of the
Let the
commissioner.
court say that. Court does not say that. Let the court say that.
Court has said in the impugned order,
Honest.
court has said so.
If that is the reason for, therefore just and necessary.
Yes, I may try, I may take
That's
the
your, see,
honorable
ನಿಮ್ಮ
court.
objection, reasons ಬನ್ನಿ.
They have not filed any objection.
ಒಂದ್ ನಿಮಿಷ, reasons ಬಂದ್ಬಿಡಿ.
I will take the
ಈ
court.
reasons ಅಲ್ಲಿ ಇದೇನಾರು ಇದ್ರೆ
Yes,
ಅದು ಹೇಳಿ. ಪಾಯಿಂಟ್ ನಂಬರ್ 1 ಬನ್ನಿ. ಏನ್ ಹೇಳಿದಾರೆ ಹೇಳ್ಬಿಡಿ. ಪ್ಯಾರಾ 8 ನೋಡಿ. ಅದ್ರ ಬಗ್ಗೆ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಇದ್ರೆ ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ದಿ ಪೆಟಿಷನ್.
kindly permit me to take the honorable court to page 54 of the writ petition file.
ರಿಟ್ ಪಿಟಿಷನ್ ಬೇಡ, ಇದಕ್ ಬನ್ನಿ. ಆರ್ಡರ್, ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ bani sir.
Impugned order, this is also an order passed by the court.
Impugned, what, this is impugned here?
This is not impugned.
Now, you come to the impugned order, one sentence saying the appeal is not maintainable, adella illa. Entire order is based on condonation of delay. ಹೌದಾ?
Order 41 rule 3
Correct.
specifically
Court
prohibits
has
the
kept
court
it.
to grant an interim order.
Sir, court has kept, correct, I am not saying interim order ಕೊಡಬಾರ್ದು ಅಲ್ಲ. Court has kept it for 1 year and now passes a delivery warrant.
I would submit, we cannot find fault within the court because it is on account of non-cooperation by the appellants.
That
They
we
did
will.
not pursue the matter.
Whatever it is, now I will direct, ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ರೆ ಏನಾಗಲ್ಲ. 1 week ಅಲ್ಲಿ 2023 ಇಂದ 1 ವರ್ಷ ಇದೆ, 2 ವರ್ಷ ಆಗಿದೆ ಈಗ. ವಿಲ್ ಯಾವತ್ತಾಗಿರೋದು ಇದು?
23 ನಲ್ಲಿ.
20 RA 40 of
This is
24.
20.
Yes.
1 week I will grant.
May make one
It should be
submission.
in accordance with law.
My only one submission, my lord. How my learned friend is lying on in the court. Page number 40, your lordship may kindly take. Order sheet of the FDP.
You have given an order
Yes,
sheet
yes.
to me, copy to me, which is not even legible, not even what has been
I-
written
I-
there. This kind of courtesy you are extending to me.
No.
You please say, I will.
How
pass
you
it
are
on the
dealing
copy.
with the court, we will
No,
see. Ma'am, only one
now
second, my lord.
There is no necessity of a blame game here.
No, not blaming you, my lord.
One
He
week
has
time,
been
for whatever
through-
reason it has
Yeah.
happened, it has happened. I will grant a week's time to the court to pass orders on condonation of delay application and reconsider this application.
No, I just wanted.
I would like to submit one thing. Now, as the honorable court was pleased to observe, right, I will be agreeable. But let there also be an order directing the appellate court to dispose of the appeal on merits as early as possible, at any rate within 1 month.
That time, 1 week.
1 month.
Appeal
No,
1
that could be done.
I will pass orders, we'll see.
My
Yes.
lords, before that, my lords,
It is,
I wanted to.
suit is of
No,
35 years
I
old.
wanted to place the record very clear.
It is of the year
Page number
45
20,
years,
it is
45
the
years.
respondent took 5 times for filing objections,
45
did not
years,
file,
I am-
did
I
not
am-
file. This is order sheet speaks. He did not file the objections.
This is why I said,
Thereafter, it was,
let us not,
yes, inquiry was held.
let us not enter into
Yes.
blame game.
No, my lords, and the fact speaks for itself.
I will
Yes.
not answer, I will not refer to that also. I
Yes.
will only say the matter
Yeah.
was pending
Yes, please.
before the court for 18 months.
Yes.
For 45 years, major portion of my life has
ಅದು
been
ಗೊತ್ತಾಯ್ತು,
before the court.
that I know.
How long I can go on agitating for?
ಅದಕ್ಕೆ court can pass any
No,
order.
no, not that.
Then what, sir?
No, I would only submit that the
No,
request I
that
am
is, that
making
is the
before the
tragedy,
court is-
can't
no,
help. But
I
that doesn't mean
understand.
that
This
in
is
accordance
the
with law, it
system.
should not
Of course,
be.
I am part of the system. What I would submit is this. Now let there be an order directing the appellate court to dispose of the appeal as early as possible.
That I will.
At
That I
any
have
rate
no
within
objection.
30 days from the date of
He
this.
he also won't be
Yes, yes.
aggrieved by it, yes. The petitioner is before this court calling in question an order dated 3/5/2025 passed on an application filed under Order 41 Rule 5 seeking condonation of delay.
No,
Seeking an interim order of stay of the final decree proceeding, final decree. The petitioner, a suit is instituted in the year 1981 in OS 152 of 1981. A decree is passed on 26/10/1988. The final decree proceedings were instituted on in the year 1990 in FDP 8 of 1990. For conclusion of the final decree, it has taken 23 years. 33 years. After which an appeal is filed against the final decree in RA 8 of 2023. In the said proceeding, since there was a delay of 39 days in preferring the appeal, the petitioner had preferred an application seeking condonation of delay. Notice is issued on the application seeking condonation of delay, and the matter goes on before the court for about 16 months. No order is passed on the condonation of delay. Without an order being passed on the condonation of delay, the application seeking stay of the final decree, stay of the order passed in final decree is not granted and could not have been granted in terms of Order 41 Rule 3 of the CPC. In the interregnum, the decree holder initiates proceedings seeking execution, initiates execution proceedings seeking to enforce the decree or the final decree. In the said proceeding, the delivery warrant is issued by the concerned court. At that point in time, the petitioner files an application under Order 41 Rule 5 seeking stay of the final decree. The concerned court, on the following reasons, rejects the said application. The entire reason rendered by the concerned court is that application seeking condonation of delay is not yet decided. Therefore, stay of the order cannot be granted. In the same breath, the executing court is now proceeding to execute the order. Therefore, the petitioner is before this court. The order sheet is appended to the petition. The order sheet is indicative of the fact that the application seeking condonation of delay has traveled for 16 months before the concerned court for manifold reasons. The reasons are not required to be noticed here. In the light of the matter being pending at the stage of continuation of delay and the stay application being rejected only on the ground that delay is not condoned, the concerned court has contradicted itself. Therefore, 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 to protect the rights of the parties or the rights to get rights to leave on frustration, I deem it appropriate to direct the concerned court to pass an application on the condonation of delay so filed along with RA 40 of 2024 within an outer limit of 1 week from the date of receipt of the copy of the order. After the order being passed on condonation of delay, the court shall then consider the application under Order 41 Rule 5 filed by the petitioner in RA 40 of 2024 within 1 week thereafter, after hearing the parties to the list. Since the suit is of the year 1980, suit is of the year 1981, and the final decree proceedings are of the year 1990, and 33 years the court has taken to pass a final decree. It is just and proper that the proceedings should expeditiously culminate. In that light, I further deem it appropriate to direct the concerned court to dispose the appeal as expeditiously as possible, at any rate within 3 months from the date of receipt of the copy of this order. Ordered accordingly. In accordance
In
with
execution, I have sought 2 prayers, my lords.
ಏನು?
2 court fee. Execution
ಇದನ್ನ
court shall
ಕ್ವಾಷೆ
be-
ಮಾಡ್ತಾ ಇದೀನಲ್ಲ.
ಅಲ್ಲ, execution court has ordered for issue of delivery warrant.
ಅದೊಂದು
No, it is there. You please see, sir.
You cannot agitate 2 matters in one writ petition.
No.
You have already filed.
ಆಯ್ತು,
a-
ಒಂದು-
court fee.
ಒಂದು-
2 court fees.
ಒಂದು ನಿಮಿಷ ಸರ್.
Yes, sir.
For the aforesaid reasons, the following order. The writ petition is allowed. The order dated 3/5/2025 rejecting an application under Order 41 Rule 5 stands quashed. The matter stands remitted back to the hands of the concerned court to decide the application within 1 week from the date of receipt of the copy of the order. After deciding the application and condonation of delay within 1 week as observed herein above, in the next 1 week, the concerned court shall pass necessary orders on application under Order 41 Rule 5 of the CPC as filed, seeking stay of the final decree proceedings. In the light of the aforesaid orders, all actions taken pursuant to the final decree proceedings, final decree in order date of the final decree dated 3/3/2023 shall all be kept in abeyance
18/1/2023.
till kept in abeyance subject to further orders of the concerned court.
18/1/23.
Yes. Next.
16,
Appeal dispose of. Appeal to be disposed of within 2 months.
ಅದೇ ಹೇಳಿದ್ದು.
ನೀವು ಮೂರು ತಿಂಗಳು ಹೇಳಿದ್ದೀರಿ. 3 ತಿಂಗಳು ಹೇಳಿದ್ದೀರಿ. ಎಷ್ಟು ವರ್ಷ ಅವನು ಕೋರ್ಟ್ ನಲ್ಲಿ ಪರದಾಡಬೇಕು ಅಂತ
ಏನ್ 33 ವರ್ಷ ಆಗಿದೆ? ಯಾಕೆ 33 ವರ್ಷ ಆಗಿದೆ?
47 ವರ್ಷ ಆಗಿದೆ. ದಾವ ಹಾಕಿ
ಯಾರು ಕಾರಣ?
ಕಾರಣ ಯಾರು ಅಂತ ನಾನು ಏನು
ಅದಕ್ಕೆ
ಹೇಳಲಿಲ್ಲ. ಕಾರಣ
we'll see. That's why I did not quote the order sheet. Both of you are at fault there.
All right. Now I am only requesting the court 3 ತಿಂಗಳಿಂದ ಬದಲು 2 ತಿಂಗಳು ಮಾಡಿ ಅಂತ.
If not earlier ಅಂತ ಮಾಡಿ.
As for the petitioner money, I have filed a suit in OS number 86 of 2025 for seeking position of the position of the suit settled property along with the application for stay injunction That application was rejected by the trial court on fiduciary grounds without looking into the materials on record,
First appellate court has also rejected it.
rejected.
Sorry.
We are here in a case where surveyor was appointed by the district court. In the district court, in the survey sketch also, it reflects the defendants have enclosed 1 kunta of land after the channel, water channel. I have produced the surveyor report appointed by the district court itself at page number 41 minute. Sorry.
Nothing wrong with the orders.
90 minute. 90.
Yes.
Because-
Both courts have held.
See, here, ಈ ಪ್ಯಾರ ನಂಬರ್ 4 ಮಾಡಿ ಈ ಬಣ್ಣದಿಂದ ಗುರುತಿಸಿರುವ ಸುಮಾರು 1 ಕುಂಟೆ ಪ್ರದೇಶವನ್ನು 306/1 ಖಾತೆದಾರರು 305/1 ಒಳಗೆ ಒತ್ತುವರಿ ಮಾಡಿರುತ್ತಾರೆ ಹಾಗೂ ಹಾಲಿ ಸ್ಥಿತಿಯಂತೆ ಮನೆ ಫೌಂಡೇಶನ್ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಅಂತ ಇರುತ್ತದೆ. This is this surveyor was appointed by the district court. They have given the surveyor has done the report and sketch. Here, what is the district court and trial court was not prima facie title. If both of them are in disputed position of the land, at that junction, status quo has to be granted by the trial court. Instead of that, the trial court has observed at para.
Anything else, sir?
Your lordships kindly see.
Yes.
Para number 19, page number 62, my lord.
It is all subject to further orders there.
See, it is a suit.
Here, position restore ಮಾಡ್ತಾರೆ ಬಿಡಿ ಆ ತರ ಇದ್ರೆ.
They are constructing the building. That is what my grievance. If suppose they have constructed a building, that would amount to multiplicity of the proceedings to the plaintiff. That is the problem with us, my lord. Hardship will be caused unwantedly. We have to go by proceedings against them.
Nothing. Yes, Ashwath Narayan Reddy.
Your lordship, that is one more thing, my lord. Your lordship, sadly, Supreme Court has.
Supreme Court.
Oh, sorry.
ಕೊಡಿ.
Supreme Court says, my lord, where the intermittent dispute over the title of land, plaintiff and defendants found to be in possession of the about half portion of the disputed land, held injunction restraining the defendant from putting off construction on entire land would be justified. The situation might become irreversible by the time disputed in decided.
Take it next week. List on 20th.
Admission 17.
17th.
20th.
20th.
Sorry, my lord. One request, my lord. ಸ್ವಲ್ಪ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೆಂಟ್ ಕೈಂಡ್ಲಿ
ಸರಿಯಾಗಿದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ, ಐ ಹ್ಯಾವ್ ಟು ಗೆಟ್ ಸಮ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ my lord.
ಮೆಟೀರಿಯಲ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ಮಂಡೇ
ಕೇಸ್ ಇಲ್ವಾ?
ಮಂಡೇ my lord.
ಕೇಸ್ ಏನಿಲ್ಲ.
ಕೇಸ್ ಇಲ್ಲ.
ಅದು ಅದಕ್ಕೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ಮಂಡೇ
ಮೊನ್ನೆ ಪೂರ್ತಿ ಕೇಳಿದಿನಲ್ಲ.
ಅಲ್ಲ ಮಂಡೇ.
ಆಯ್ತು ಒನ್ಸ್ ಇವತ್ತು ಟೈಮ್ ಇಲ್ಲ ಎನಿವೆ. ಎಸ್ ಲಿಸ್ಟ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ as a last chance. Next. Wednesday ಇಲ್ಲ, Thursday. 19th.
19. All right.
Interim order subsisting will continue to the next date.
18.
For the petitions, the executing court, my lord, on the alleged, my lord, violation of injunction order in respect. Yes. Operative portion is, my lord, date was given yesterday, it was not posted there.
ಅದಕ್ಕೆ ಇವತ್ತು ಬಂದಿದೆಯಾ?
Civil imprisonment order is passed on the alleged violation of injunction order in respect of 1F2, my lord. I am the owner of 1F3. On the basis of the I sketch, in so far as other orders is concerned, I will not insist, only in respect of civil prison advocate commissioner was appointed. Let him survey the land and, my lord, if I am encroached, let him punish, my lord. Otherwise, before that, my lord, imprisonment order.
Insofar as his submissions regarding civil imprisonment, my instructions are, we will not precipitate that matter. My lord, the decrees of the year 1998, 2 executions prior to this have been filed. And again, time and again, the obstructions have been created by.
File your objections.
Please.
List the matter on 26th.
Please.
The learned counsel for the respondent undertakes that he would not precipitate the proceedings where he has sought for housing of the petitioner in civil prison. Yes.
Obliged, Lords.
Next, yes, next.
Orders 19.
To comply the office objection, my lord.
Interim order ಇದೆಯಲ್ಲ?
Interim order, further investigation ಕೇಳಿದೆ. Interim
Oh,
order.
further investigation.
Further.
ಯಾರಿಲ್ಲ. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ ಫಸ್ಟ್? ಏನ್ why further investigation?
This honorable high court, my lord, has already said the matter. Even though, my lord, investigated the matter and filed a B report as against respondents and charge sheet is has been. Main accused, my lord, they purchased the property in the 48 crores property they purchased only in the meager amount. And accused number 1 to 4, my lord, they obtained that amount. And only as against accused number 1 to 4, they filed a charge sheet. This honorable high court, my lord, their petition itself, my lord, they granted the interim order. And in the charge sheet, they said that, my lord,
Yeah, which is that interim order?
in 5387 of 2000 connected matter, my lord, 5387 of 2024 one.
Tag this petition along with WP, writ petition or criminal petition?
Criminal petition.
5387 of
2023, sorry.
List next Thursday. 23 or 24 other?
23,
23 na?
please.
All right. Yes, good.
20.
Appearing for petitioners in this matter, your lordship, the judgment in this matter has attained finality on once.
ಅದು ಗೊತ್ತು. Where is Jafar? Yes, madam, get Jafar. Yes, pass over. ನೀವೇನ್ ಇರೋದು ಬೇಡ, will see.
21.
Carry on. I'll get post immediately after service of notice upon the first respondent.
22.
Kindly extend the interim order in 21.
Interim order extend ಆಗುತ್ತೆ.
First point number 6 ಇವರಲ್ಲ. Deputy of the petitioner.
Hmm.
The needful has been done in so far as
Learned counsel submits needful has been done. Office to verify.
the other
Objection,
objections are to be complied with
non-rectification of
by the other side. ಕೊಟ್ಟಿದ್ದೀವಿ ಅವರನ್ನ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಇದು ಅಪ್ಪಾಗಿದೆ.
Learned counsel for the respondent submits that the office objections the statement of objections have been complied with. Office to verify. ಇನ್ನೇನಿದೆ?
ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್
vacating stay ಇದೆ.
ಅದರಲ್ಲೇನೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕಾಗಿರೋದು.
ನೀವು
ಹಾಕಿದ್ವಿ ಅವರನ್ನ.
Complied, yes. We'll take it on Wednesday then. ಇವತ್ತೇನಾಗಲ್ಲ. What's the suit for?
A suit for partition in fact.
What is the order under challenge?
Milord, order is, Milord, it is, application was filed under order 21 rule 35, seeking, and also read with order 40, seeking appointment of a receiver in an FDP proceedings to in fact evaluate the mean profits, which has not been in fact even granted in the suit.
List on Wednesday.
Interim order may kind.
Interim order subsisting will continue to the next date of year.
ಇವರ ಒಂದು ಸಬ್ಮಿಷನ್ ಇದೆ ಅಲ್ಲಿ. ಇವರು ಹೈಕೋರ್ಟ್ ಅಪ್ರೋಚ್ ಆಗ್ಬೇಕಂದ್ರೆ ವಿತ್ ಕ್ಲೀನ್ ಹ್ಯಾಂಡ್ ಬರ್ಬೇಕಿತ್ತು, ಕ್ಲಿಯರ್ ಆಗಿ. ಅಲ್ಲ ಹೇಳ್ತೀನಿ ಇವರ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರು ಫುಲ್ ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಕೊಡ್ಕೊ ಬರ್ತಿದ್ದಾರೆ. ಮೊದಲನೇದಾಗಿ ಇವ್ರು ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಡ್ರೆಸ್ ಎಲ್ಲ ತಪ್ಪಾಗಿದೆ. ಸದೋಗಿರೋನ ಬದುಕಿದ್ರೆ ಅಂತ ತೋರ್ಸ್ಕೊಂಡು ಹಾಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ ಇವರನ್ನ. ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೂಡ 13 ವರ್ಷಗಳಿಂದ ಸತೋಗಿರೋನ ಬದುಕಿದ್ದಾರೆ ಅಂತಾನೆ ತೋರಿಸ್ತಿದ್ದಾರೆ. ಇಲ್ಲೂ ಕೂಡ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಇದಾರೆ ಅಲ್ಲಿ.
ಅವ್ರು ಯಾವಾಗ ಸತ್ತೋಗಿದ್ದಾರೆ?
ಅವರು ಲಾಸ್ಟ್ ಇಯರ್ ಸತ್ತೋಗಿದ್ದಾರೆ ಇವರನ್ನ. ಅಲ್ಲಿ ನಾನು ಅದಕ್ಕೆ ಹೌದು ಇವರನ್ನ ಗೊತ್ತಿಲ್ಲ. ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಏನಿದೆ ಅದನ್ನೇ ಹಾಕಿದ್ದೀನಿ.
13 ವರ್ಷದಿಂದ ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ.
ಚಿಕ್ಕದೇವಮ್ಮ ಇವರನ್ನ ಅವರು ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಆಗಿದ್ರು ಇವರನ್ನ ಓಎಸ್ ಕೇಸ್ ಅಲ್ಲಿ. ಇವತ್ತಿಗೂ ಕೂಡ ಹಂಗೆ ತೋರಿಸ್ತಿದ್ದಾರೆ. ಅದು ಇನ್ನೊಂದ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇವರನ್ನ ಅದನ್ನ ಇವ್ರು ಕೊಲೆ ಮಾಡಿದ್ರೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನಾವು ಎವಿಡೆನ್ಸ್ ಗಳು ಕೊಟ್ಟು ಕೇಸ್ ನಡೀತಿದೆ. ಅಲ್ಲಿ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟರು ಕೂಡ ಪ್ರೂವ್ ಆಗದೆ ಅದಕ್ಕೆ ಈಗ ಅದೇ ರೀತಿ ಮಾಡಕ್ಕೆ
ಬುಧವಾರ ನೋಡಿ ಲಿಸ್ಟ್ ಆನ್
ನೆಕ್ಸ್ಟ್ ಮಚ್ ಎಂಟ್ರಿ ಮಾಡೋದು
ಎಂಟ್ರಿ ಮಾಡಿ
ಮಚ್
ಎಸ್
23.
My lords, in this case.
A week's time is granted to
My lords,
comply
what
with
has
the
happened?
office objections.
My lords, one submission, my lords.
Monday.
My lords, one submission is 2466, there was an order granted that I had to comply the office objections within 2 weeks in the vacation court. On 28th, that is before the lapse of the, I did it. The same contention was taken by the respondent before the lower court, And the lower court has taken 2 weeks time granted as 2 days time. My lords, that is what,
ಅದೇನಾಯ್ತು? Yes, yes.
my lords, there, the matter is being posted for.
1 minute, sir. List the matter on 23rd in preliminary hearing. Notice ಆಗಿಲ್ವಾ?
A notice ಆಗಿದೆ ಸ್ವಾಮಿ. Notice ಆಗಿದೆ. ಅವ್ರು
ಯಾರು
ಕೂಡ-
notice ಆಗಿದೆ? Yes. On 23rd in preliminary hearing.
23rd ಆ lower court ನಲ್ಲಿ judgment
This court-
post ಮಾಡಿ.
This court on 17/2/2025 had passed the following order. Interim order was granted and subject to the condition that the office objections would be complied with in 2 weeks. The learned counsel for the petitioner submits that the concerned court has observed that this court had granted 2 days time and not 2 weeks. And therefore the matter is now posted for its judgment before the concerned court. In the light of comply ಮಾಡಿದಿರಾ ಇಲ್ವಾ?
Complaint 28th ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ, but
The
further
learned
office
counsel for the
objections raised.
petitioner submits that the office objections were complied well before 2 weeks' time. In view of the obfuscation generated by the concerned court, the concerned court serious prejudice is caused to the petitioner. Therefore, there shall be the interim order that is granted on 17/2/2025 shall stand extended till the next date of hearing.
Much obliged.
Yes. Non-compliance ಅಂತಾನೆ ಬಂದಿದೆ ಮತ್ತೆ?
ಫರ್ದರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೈಸ್ ಆಗಿದೆ.
ಈಗ
ಅದನ್ನ
further-
ಮಾಡಿದೀವಿ ಬಟ್
Anyway, yes, next.
ಮಚ್ obliged.
24,
A week's time to comply with the office objections. Next,
25,
same order.
For the petitioner, my lords.
Week's time is going to comply with the
Your
office.
Lordship, the matter was heard on Monday. There was no office objections. The matter was listed for preliminary hearing. But now
ಮತ್ತೆ-
for some reason, I don't know, it's for orders listed there, but I'll compare with the office objections, my lords. And my lords, the application is regarding my application of cross-examination has been disallowed, my lords.
ಇಲ್ಲಿ
On
ಎರಡು
payment,
objection
on
ಇದೆ.
payment of cost, it may be allowed, my 19.
List on,
ಅಲ್ಲ, the.
list on Monday, office objections be complied.
ಅಲ್ಲ,
with.
ಆಗಿದೆ ಸ್ವಾಮಿ, the office objections.
ಇನ್ನೊಂದಿದೆ ನೋಡಿ ಸರ್.
ಅಲ್ಲ, it's only council, await council submission ಇದೆ, my lords. There are
ಎಲ್ಲಿದೆ
other-
council submission?
there are other defendants who have not been made party. They have already been placed ex parte. They are not the contesting defendants.
Accepting the submission of the
may be
council to the
overruled.
petitioner, the office objections overruled, list on Monday. Yes.
And insofar as my lords, the
Placed
application.
on
my lords,
Monday.
26,
Obliged.
Yes. One week to comply with the office objections. Next,
Much obliged, man.
27,
a week's time is granted to
Number
the
10.
needful.
For the
I
petitioner.
have still not been served a copy of the petition on the last occasion.
Already taken
also.
out PF also, my lord, second
ಒಂದು
time.
ಕಾಪಿ
I
ಕೊಡಕ್ಕೆ
was
ಏನು
here.
ಇವ್ರಿಗೆ?
I'll give it right away, my
I
lord.
was here, I was present my lord, also because the interim order is troubling me. I have purchased the property for 24
ಈಗಲೇ
crores.
ಕೊಡ್ತೀನಿ, ಈಗಲೇ ಕೊಡ್ತೀನಿ. It may be also mentioned, I undertake to give a copy. ಇನ್ನೇನ್ ಹೇಳಿ ಸ್ವಾಮಿ ಅವ್ರು? ಅಲ್ಲ, ಅವತ್ತು
List
ಕೊಟ್ಟಿಲ್ಲ
on,
ಅದಕ್ಕೆ.
list on Wednesday, petitioner to serve set of papers upon the council, Siddharth Suman, forthwith.
Please.
Yes, interim order ಇದೆಯಾ? ಇಲ್ಲ ವೆಕೆಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ನಾನು. Yes,
ಈಗಲೇ ಸರ್.
Wednesday, next.
Nan matra my lord, because the others, it's all coming up in orders only because the others have not been served.
I will see, yes.
Lord, one more submission was that let them not change the nature of land, my lord.
Wednesday, yes.
Great.
ಕಾಪಿ ಕೊಡದೇನೆ ಏನೇನೋ ಕೇಳ್ತಾರೆ. Yes,
ಅಲ್ಲ,
Please.
next.
28,
Post immediately after service of notice upon the first respondent, interim order continue ಮಾಡಿ.
29,
Same order. No time now, yes.
Not today. They will not comply with it.
ಯಾರದು ಎಲ್ಲಿ ಇಲ್ವಾ ಅವರು ಯಾರು? Petitioner ಯಾರು?
Your lordship, I am appearing for the impleading respond number 8.
Impleading ಈ ಕಡೆ ಬನ್ನಿ. No representation behalf of the petitioner. In the event the needful is not done by the next date, the interim order subsisting would stand automatically vacated.
Undertaking to the court that we will not withdraw the money. There is some land compensation which is deposited in our account.
I will take it on Friday next.
Let them.
List on 20th.
Let the undertaking be continued, your lordship.
Undertaking of any kind subsisting shall continue till the next date of hearing. Next. Next Friday.
30,
Post immediately after service of notice upon the respondent.
But I have filed wakalat and publication.
Learned counsel, ನಿಮ್ಮ ಹೆಸರಾ ಇವ್ರದ್ದಾ? Learned counsel Kalyan Basaraj submits that his entered appearance for the
The
respondent
petition
registry,
itself is not
registry to print the name of so and so as appearing for the respondent.
But the as against it.
List on Monday.
Well, as against the interim, ex parte interim order, they are
List on
before this court.
Monday.
No, it is covered by the judgment of the Supreme
Monday.
Court. No, they
Petitioner idara?
are, no, they are threatening my possession on the basis of the interim order which they have obtained.
Where is the petitioner? ಮತ್ತೆ?
Abrala ಅವರು. They are enjoying the benefit of
Monday,
the.
sir. List on Monday. There is no representation way of the petitioner. List on Monday. In the event there would be no representation, the interim order would stand automatically vacated.
Serial number 30.
Eಲ್ಲಿದ್ದೀರಿ sir?
Sorry, minutes. I was engaged in some other court.
I'll vacate the interim order now.
Minutes, please. Let's avoid service of notice to
Don't
respondent.
bother about that. He is there.
Respondent number 3, minutes, Kalyan Nagar.
ಪರವಾಗಿಲ್ಲ, ನಿಮ್ಮ maintainability ಮೇಲೆ ಹೇಳಿ.
It's short accommodation may be given.
Monday.
Please, minutes.
Yes, next.
Great.
31.
For the petitioner, not additional court fee had to be paid, I have paid. There are no other office objections. The urgency is not.
Monday.
I have.
Monday ಅಲ್ಲ Wednesday. Yes.
Today they may execute the decree.
What were you doing till now?
Not immediately I filed this writ petition. Not, my application for obstruction is rejected. Subsequently, I filed an application under 1 Rule 10.
Monday.
Yes. Please.
Saturday, Sunday execute ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಇವತ್ತು ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಬಹುದು.
Yes, next.
32.
Passed over by 1 week. Yes.
No, sir. Matter is
Next.
posted on Monday, my lords.
ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಇವತ್ತು ಕೇಳ್ತಾ ಇದ್ದೀರಾ? Monday, yes.
Monday.
List on Monday.
Make one office objections complied.
ಓವರ್ ಮಾಡಿದ್ನಲ್ಲ ಇಲ್ವಾ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಓವರ್ ಮಾಡಿ. Next. 32. 33. Early hearing. List the matter on 2nd July. Next.
Serial number 19, 11 and 20th, minutes, 18.
We'll see, yes. ಅದು ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್ 20th. 34.
34.
23. List on 9th July. Yes.
30.
Interim order subsystem will continue. Next. You're silent ಮತ್ತೆ?
This is that matter where Chawda sir had argued with your lordship, 399-402 when I'm in police custody.
Oh, correct. Interim order ಇದೆಯಲ್ಲ?
But there is no interim order, my lord. It is just that the charge is different.
ಅದೆಲ್ಲ ಒಂದು indirect interim order ಅದೇನು?
In fact, on the last date of hearing.
Let him come. List on
Monday, my lord.
Tuesday.
Great.
36.
We'll take some time next week.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ, it's for consideration of my.
20th. Yes, list on 20th.
37.
My lord, extension.
ಎಲ್ಲ extension of parole.
Premature release. He has surrendered on 9th, my lord. In other 3 matters, Monday is the last date to surrender. In 2 months, honorable governor will take a decision.
ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅದೇನಾ?
I'll not move.
ಯಾರು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ? Nobody.
Rahul has communicated. Rahul has communicated.
ಎಲ್ಲಿಗೆ? Ask Rahul to come. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ಎಲ್ಲ.
Published.
42 ಬನ್ನಿ ಸೀದಾ. ಅಲ್ಲ 41. IA for extension filed by advocate. What extension is?
41.
This court had ordered me to deposit 50% of the decretal amount. 25% I have deposited. Another 25, 15th ವರ್ಗೂ deposit.
ಅವತ್ತು ಆರ್ಡರ್ ಆಗಿದ್ದು ಯಾವತ್ತು?
27/3.
27?
27/3.
June 2025. 2 more weeks time.
First installment I have paid.
ಆಯ್ತು, ಇನ್ನು ಸೆಕೆಂಡ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಇನ್ನು 2 ವಾರ ಕೊಡ್ತೀನಿ. This court on 27/3/2020 order IA ಅಂತ.
4 weeks.
27/3/2025 had passed the following order. 25% has been deposited and the remainder is was to be deposited on or before 15th June.
Please,
An application is filed seeking extension. Owing to the circumstances narrated in the application, 4 more weeks time is granted. The deposit of another 25% be made on or before the 15th of July 2025.
Much.
Failing which the interim order would stand automatically vacated.
42.
Please, my lord, this was a matter where I had filed a writ petition against an order because I was not served.
ಬುಧವಾರ.
Yes, my lord. I had earlier given an undertaking orally that I am continuing voluntarily. I am saying.
The
That
vacating
cannot be-
interim order ಇದೆ?
ಅಲ್ಲ, ಅವ್ರು ಹಾಕಿದ್ದು ನಾನಲ್ಲ.
ಅಲ್ಲ, ಏನ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
Orally I had submitted.
Oral undertaking vacating interim order ಹಾಕಿದಾರಾ?
No, no, no. The vacating interim order he has filed because this honorable court was pleased to stay the interim order.
ಅದ್ರ ಮೇಲೆ ಏನ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ರಿ ನೀವು?
I said I will not dispose of the property.
Dispose of the property. All right, yes. List the matter on Wednesday.
And in trial court, it's being argued today.
All right, yes.
43.
So for the respondent, maybe for me to file my objections. It's a matter where, my lord, without notice, my lord, amount has been directed to be withdrawn in the executing court. My lord, amount is deposited subject to the final outcome, my lord, that is the order passed in the pending commercial appeal here. My lord, they advance the matter and, my lord, file an application for release of the amount without giving us an opportunity, my lord, 16.5 crores. Can I submit? 17.5 crores, sorry.
1 ಕೋಟಿ ಬಿಟ್ಬಿಟ್ರಲ್ಲ ಧಾರಾಳವಾಗಿ. Yes. Yes.
I deposited with them 17.5 crores as a refundable deposit.
So should he not be heard?
My lord, please see ink page 50, my lord. They have admitted to the amount. The award is in my favor. The section 34 court modified the award. Insofar as the interest.
I am only on the fact that whether.
Yes, yes, please see, my lord, ink page 50. No doubt it's true that DHR and JDR have challenged the order passed by this court in respect of a petition under section 34 of the Arbitration and Conciliation Act. Admittedly, there's no stay of the execution petition. The learned counsel for the
Judgment
JDR
debtor
is not disputing
the award
Yes,
amount. But
this
only
is not under
disputed
challenge. This order is not under challenge.
Interest ಕೊಟ್ಟಿದಾರಾ principal?
Principal and
ಮಾಡಿಲ್ಲ.
yes.
My lord, that is actually wrong. I have filed my memo. Please look at.
There's no challenge to this order.
My lord, final order is against him. It is only an observation. Please see the memo which we have filed in writing.
We'll take it on Monday.
Yes, ma'am. Very well.
Monday. Yes. List on Monday.
Preliminary.
Don't call B group. We'll give date.
Grateful.
For the hearing. Go.
Further hearing. So 50.
It will be adjourned, sir. Interim order either continue ಆಗುತ್ತೆ. No interim order, ಅದೇ continue ಆಗುತ್ತೆ. ಇನ್ನು further hearing ಈಗ ಕರೆದಿದ್ದೀನಿ ಒಂದು. Yes. Rahul, wait.
Serial number 47, my lord. There is an interim order.
That will continue, sir.
No, it has not been continued on the last occasion.
Then it will definitely continue, sir. When an interim order is granted, it should be vacated by a reasoned order, not by this method saying it is not continued earlier. That will come, yes. You should get the order vacated by arguments, sir, not these technicalities. All right, 19, not 19, 20th. Further hearing, baby ಪಾಟೀಲ್ ಇಲ್ವಲ್ಲ? ಅದು ಯಾವತ್ತಿಗೂ ಹಾಕಿದೀವಿ ನಿಮ್ದಲ್ಲ ಸರ್. ಎಸ್ ಈಸ್ ಔಟ್ ಆಫ್ ಕಂಟ್ರಿ. 26th ವಿಲ್ ಟೇಕ್ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ.
ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಮೆಲೋಟ್ಸ್ ಏನಾಗಿದೆ
ಡೆಫರ್ ಮಾಡಕ್ ಹೇಳಿದೀವಲ್ಲ.
ಇಲ್ಲ ಅದು ಆಗಿಲ್ಲ. ಏನಾಗಿದೆ ಮೆಲೋಟ್ಸ್, ವೆನ್ ಐ ಫೈಲ್ ದಿಸ್ ಪಿಟಿಷನ್ on the ground of exoneration, this court
departmental inquiry
this court has granted me the interim order, though I had not filed an application. Then I brought it to the notice of my lord, saying that I have not filed an application.
Now you have filed an application.
Then this court has clarified that application is not there. Somehow the matter
ಆಮೇಲೆ ಹಾಕಿದೀರಾ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ. Somehow the matter is proceeding.
Anyway, somehow we can't grant an interim order now.
So that's why
I would like to submit this document where these witnesses are not examined, your lordship.
I thought one copy code.
I've served.
Copy code. We'll take it on 26th. ಏನಆಗಲ್ಲ. Yes. Next.
51.
Any date convenient to your lordships. Interim order maybe.
We'll release it.
Right.
Let it come before the.
Very good.
Release the matter from the status of being part heard and post the matter before the bench having roster. Interim order, if any, shall continue till the next date of hearing.
Great.
He moved it only for that. Yes.
52.
ಎಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ ಕೋರ್ಟ್ಗೆ? 4ನೇ ಸರಿ ಬರ್ತಾ ಇರೋದು ಇದು. It's not correct. And I've heard you at length. ಏನು ಉಳಿದಿಲ್ಲ ಇದರಲ್ಲಿ. ನಾಯಕ್ ಸರ್ ಅಪಿಯರ್ ಆಗಿದ್ದಲ್ವಾ? Is extensively heard.
Yes, my lord. It's extensive.
Reserved, yes. ದೇವಸ್ಥಾನದ ಪಕ್ಕ.
Please.
Slum, yes.
My lord, request, we'll file a written synopsis.
Please do it.
Please.
ನೀವು
we'll do
ಹಾಕಿ ಮಹೇಶ್.
it. Please. Wait.
Yes.
53.
Lord, I appeal for the respondent in this matter. Respondent number 3. Lord, in fact, my lord, at an earlier point of time, my lord, your lordship was pleased to hear us and reserve the matter. Thereafter, my lord, it has been posted for further hearing.
Reserve ಮಾಡಿದ್ನ?
ಹೌದು.
Then next Friday.
Please.
ಇದು ಅಷ್ಟೇ.
54.
My lordship, this is the matter for grant of alternate land, 2 acres of land. Any date may be fixed.
Friday, next Friday.
55.
Appealing to the petitioners of
Respondent, my lords. ಅಲ್ಲ next Friday ಬರ please entry order continue.
interim order.
Okay.
56.
Same
Correspondent number 2.
next Friday.
57.
They appear for the petitioner, my lords.
Yes, Vinay.
This is a matter where the police themselves are investigating the case where they are the accused.
ಇದೇನು ಉಳಿದಿದೆ ಇವತ್ತೇನಾದ್ರು? What remains here? This is that Rania Rao's mother, right?
No, my lords.
Rania Rao ಅಲ್ವಾ ಇದು?
This is a case. ಮರ ಎಲ್ಲ ಕಟ್ ಮಾಡಿ ಅದು FIR ಅವರೇ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತಾರೆ. Lords were pleased to direct them. B report, my lords, they give us an intimation.
They issued an endorsement saying that we will file B report. But my instructions are that it has not been submitted to the court. We have withdrawn that, your lordship. We have withdrawn that. My submission may be.
The learned AGA Rahul Karyappa on instructions from yaradu, who is that? From the station house officer of Nuggenhalli Police Station submits that the B report, though was sought to be filed, has been withdrawn, and as on today there is no B report presented before the concerned court. Therefore, as observed on 3/6/2025, there is no violation of the order is the submission. The learned counsel for the petitioner seeks time to secure instructions and make submissions Wednesday.
Lords, interim order mechanism.
Interim order subsisting will continue to the next.
Oblige, my lords.
ಆಯ್ತು, ಇನ್ನೊಂದು ವಾರ ಕೊಡ್ಲಾ? ಆಯ್ತು. List the matter on 4th July. Yes.
Oblige, my lords.
Next.
58.
Lordship, the objections are ready. I'll file.
Learned counsel for the respondent submits, respondent 7 to 12 submit that the objections are ready and would be filed in the next 2 days. List the matter again next week, 20th.
Next 2 days ಅಂದ್ರೆ ಅವರು ಉಡುಪಿಯಿಂದ ಬರಬೇಕು. ಸೊ
ಆಯ್ತು, 27th. Interim order ಇದೆಯಾ? Interim order subsisting will continue till the next date of hearing. Yes, Nagaraj.
Regarding further investigation, my lord, bank clerk's wife has filed the 498 and 314 of DP Act against the husband, my lord. The police seizes the locker, my lord, bank lockers, my lord, regarding the gold ornaments. But for the filing of the charge sheet, they do not open the locker, do an inventory, or logbooks are not presented before the charge sheet, my lord. It is not mentioned in the charge sheet, and cognizance has been taken by the magistrate, my lord. Further investigation only regarding the limited purpose, my lord.
ಆಯ್ತು, ನಾನು 20th ತಗೊಂತೀನಿ. List on 20th.
request for next Friday.
Lord, I have filed an application for intervening on behalf of the Lord Kannada Sahitya Parishad.
So that also I'll file my objection.
Lord, I take 5 minutes of your lord.
Still no apology?
That's why, my lord. Lord, they approach this court creating complete abuse of process of law. They have taken judicial time of your lordship. Kindly give me 5 minutes time of your lordship. Lord, these are my submissions in support of the stand taken by respondent.
ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
Copy ಕೊಟ್ಟಿದೆ.
Yes, Lord, I have already served the copy. Lord, these are my submissions. I make it very brief. May pass.
What happened before the Supreme Court?
Supreme Court, my lord, the association of the theatre owners.
ಅದಾಯ್ತು.
Today notice is issued. Just notice is issued. No order as such. Lord, my submissions are these: that the petitioner, which is a registered partnership concern, has invoked the part 3 of the Constitution of India. Kindly see the first paragraph in the writ petition itself.
But such a writ petition is not maintainable. There is a judgment of the Supreme Court as well as the Madras High Court that a person, a company or registered partnership concern cannot invoke Part 3 of the Constitution because it is not a citizen. They have not made the partners of the first petitioner, the petitioner as a party in the present writ petition. And they specifically in paragraph 1 say they invoke Article 19(1)(g) of the Constitution. That is my first submission. The second submission, well, kindly see, a person who has set his house on fire, that cannot come before this court and seek, Lord, please permit me to or help me to douse the fire. The 12th century Basavanna said, Manayolagana kichu manaya suttallade naramariya sudude kodala sangamadeva. He has set his house on fire by his own conduct. Now he is crying before this court, please douse off the fire. Not one cannot be an arsonist and a firefighter. He is not even a firefighter. That's a different thing. A person who creates a controversy and incidentally invites the trouble cannot seek the extraordinary jurisdiction of this honorable court to rectify or even to redress the grievances created by him. Not submission number 3. A person, my lord, who invokes Part 3 should have equal respect for other parts of the Constitution. Not 50 Part 4A, 51A specifically says every citizen should have respect for the language, culture, and other aspects of the nation as such. The unity and integrity of the nation has to be maintained. And secularism, Lord S.R. Bommai says, is a basic feature of the Constitution of India. Lord number 4, Lord, this is most important. It's high time, Lord, being stupid is not a crime in India yet, but making a false state, not yet. I verified from the legal perspective, it's not
Your Lordship,
a crime
the language is very unfortunate, Your Lordship.
Yeah. Being stupid is not a
For a
crime.
petitioner, Your Lordship, the language is very
Being
unfortunate.
stupid is not a crime yet. I will demonstrate. That was a stupid statement. I will repeat it.
No,
Right.
let us not.
Therefore,
no.
what they say is not only that, making a statement.
See, we'll keep the proceedings. We'll keep the decorum of the proceedings fine. Not use any.
But I can use preposterous. I will use the word preposterous.
Polish ಹೇಳ್ಬೇಕು.
Yes, that's not my style because I am hurt by the reason that if somebody says, if I use this word, if somebody says,
no, whoever it
hello,
is, see, one thing is, whoever it is, that in a court of law, it is not correct to call someone stupid. It's not.
I said stupid statement, not the person. But I have greatest regards for this man because he has demonstrated being silent. He is a noble thing by his movie Pushpaka Vimana. I say that being silent is a golden. I said the statement, not the person. I correct myself.
Yes.
It is not in dispute. In paragraph 10, they say that Mr. Parthasarathi Srinivasan, alias Kamal Hassan, used the word that Kannada was born from Tamil. Lord, I will give a very simple example because it is part of judicial proceedings also. If somebody calls other person, hello brother, or hello father, that is not a slang. In Kannada, there is what is yes. If somebody says hello son, that's a slang. If somebody is born to somebody else, but this is what exactly I said in paragraph 10. He says Mr. So and so called Kannada is born out of Tamil.
See, that is a statement that he has made. That is a statement that he has given some explanation of. And that is the statement
he says out of love.
No, that is the statement that the court also asked him whether he would apologize.
But he says he said out of love. Nobody calls another person as a son out of love. You may call his brother as a love or father out of love. Nobody says.
All right,
may I pass on this just to demonstrate the falsehood.
The impleading application gave objection act.
Your Lordship, yes, Your Lordship.
This is the important aspect. How the we will sign it.
Who is the impleading applicant?
Applicant is Kannada Sahitya Parishad. But I apologize. I use the word stupid only for the comment. Absolutely no ill against the veteran. Kindly see, my lord. I rely on 3. I only say he admits that he is neither a historian nor a linguist. If only a person is educated, but he would not make that irresponsible statement and justify it and refuse to even regret it. But kindly see, there are 3 books I read. First one is Kannada Lipya Ugama Mat Vikasa. These are the books which are age old. And kindly see, I will only take 2 minutes.
No, you serve a copy.
I've already served.
And place it on record. let me also have the benefit of
Only
seeing
one
it.
paragraph, only one paragraph. I will not read anything more than that, so that let him convey to his client, only one paragraph. Only one paragraph,
Yes.
para 9, page 9. Let him communicate so that he will come wiser on the next date of hearing. Para 9, Miller?
All right,
Yes.
yes.
ಮಹಾಭಾರತದಲ್ಲಿ ಕರ್ನಾಟಕ ಶಬ್ದವಿದೆ. ಕ್ರಿಸ್ತಶಕ 1ನೇ ಶತಮಾನದ ಎನ್ನಲಾದ ಮಾರ್ಕಂಡೇಯ ಪುರಾಣದಲ್ಲಿ ಉಕ್ತವಾಗಿರುವ ದೇಶಗಳಲ್ಲಿ ಕರ್ನಾಟಕ ಹೊಂದಿದೆ. ಸೋಮದೇವನ ಕಥಾ ಸರಿಸಾಗರ ಮತ್ತು ವರಾಹಮೀರನ ಬೃಹತ್ ಸಂಹಿತೆಯಲ್ಲಿ ಕರ್ನಾಟಕವೆಂದಿದೆ. ಶೂದ್ರಕನ ಬೃಚ್ಚಕಟಿಕ ನಾಟಕದಲ್ಲಿ ಒಂದು ಪಾತ್ರವಾದ ಚಂದಕನ ಕರ್ನಾಟಕ ಎಂದು ಹೇಳುತ್ತಾನೆ. ಗಂಗಾ ವಿಕ್ರಮನ ಬೆದಕೂರು ಶಾಸನದಲ್ಲಿ ಅಸಮಸೀಮಾ ಕರ್ನಾಟಕ ಎಂದಿದೆ. ಸಂಸ್ಕೃತದಲ್ಲಿ ಕರ್ನಾಟಕ ಎಂಬ ರೂಪಗಳಿವೆ. ಕರ್ಣೇಶು ಅಟತಿ ಕರ್ನಾಟ ಎಂಬ ಶಬ್ದರತ್ನಾವಳಿ ಮತ್ತು ವಿಷ್ಣು ಗುಣದರ್ಶ ವಿವರಣೆ ಇದೆ. ಎಂದರೆ ಕಿವಿಗಳಲ್ಲಿ ಬಿದ್ದು ಪ್ರಸಿದ್ಧವಾದದ್ದು. ಸ್ಕಂದ ಪುರಾಣದಲ್ಲಿ ಕರ್ನಾಟಕ ಎಂಬ ರಾಕ್ಷಸರು ವಾಸಿಸಿದ್ದರಿಂದ ಹೆಸರು ಬಂದಿದೆ ಹೇಳಲಾಗಿದೆ. ಪ್ರಾಕೃತದಲ್ಲಿ ಕನ್ನಡ ಎಂಬ ರೂಪ ಬಳಕೆಯಾಗಿದೆ. This historical background let my learned friend communicate to both so that he will come wiser on the next
objections to
hearing.
this impleading application, you file.
Yes,
But counsel on record.
Blood, I appear
Counsel
for
on record, is there on?
Mr. Shubhang.
What's his
But
name?
Shubhang Nair.
Shubhang.
But I appear for Mr.
Yes,
Chintan Chinnappa.
Heard the
Brothers fighting over the mother tongue.
heard the learned.
He appears for
yes,
the
yes. Heard the learned counsel. The what is it? Karnataka?
Kannada Sahitya Parishad.
Kannada Sahitya Parishad has filed an impleading application to implead itself as a party to these proceedings. Learned senior counsel S. Basavaraj, appearing for the impleading applicant, has made submissions as to why he becomes a necessary party in these proceedings. The learned counsel for the petitioner seeks a week's time to file statement of objections to the impleading application and also make submissions. The interim order that is passed, the order that is passed on 3/6/2025. List the 20th.
20, very good.
List the matter
Obligation.
on 20th.
My application for intervening
ಅದು ಹಾಕ್ಬಿಡಿ, ಅದಕ್ಕೂ ಹಾಕ್ಬಿಡಿ objection.
ಅದಕ್ಕೂ ಹಾಕ್ತೀನಿ.
We'll file objections.
The learned counsel for the petitioner would further seek to file statement of objections on IA number? IA 1 of 25, seeking to, who is the impleading applicant?
Advocate Mr. Amrutish.
Sir, so to the application so filed on 3/6/2025 itself. Yes. Objections to the applications be complied, filing of objections to the applications be complied by the next date. List the matter on, the undertaking would remain. List the matter on 20th. The order dated 3/6/2025 shall continue till the next date of hearing.
Blood, I express my regret over the word. It's not against the person, it's a
That's all.
statement.
You clarify.
The emotions fly.
I'm obliged to my senior for clarifying.
Yes, yes.
Obliged. Yes, sir.
No, no problem. I have no problem.
That is the humanity.
No, I myself clarified.
We are a human beings.
No, Basavaraj sir will never do that. Yes.
We are supporting you.
That's all right. Counsel, again I'm repeating, discretion is the best part of valor.
Your Lordship, we will convey your Lordship. Obliged.
Great.
ಪಾಸ್ವರ್ಡ್ ಅಲ್ಲ, ಪಾಸ್ವರ್ಡ್ ತಗೊಳ್ಳಿ. ಅದೊಂದು ಯಾವುದೋ ಇತ್ತಲ್ಲ ಮಾಡಿ. ಒಂದು ನಿಮಿಷ. You want to go somewhere? ಹೋಗಿರಿ. Come at 1:15. That's enough. ಅಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡ್ಬೋದಾ ಎಕ್ಸ್ಟೆನ್ಷನ್? ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 609 ಐತಲ್ಲ.
Yes, surrendered on 9.
ಅಲ್ಲ ಈಗ 60 days ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ಎಲ್ಲ. ಇದು all these cases.
Other matter, Monday is the last date to sign.
ಎಲ್ಲದರಲ್ಲೂ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಪರೋಲ್ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ, ಅದನ್ನ ಮಾಡಿ. Yes. No problem. We carry on. Yes.
So kind of.
Yes. ಇಲ್ಲ 30th ಪರೋಲ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಲೋಡ್ ಅಲೋಡ್ ಇಲ್ಲ. ಫಾರ್ಮ್ಯಾಟ್ಸ್ ಅದು ಪಾಸ್ವರ್ಡ್ ಕರಿ.
Password seal number 9.
ಮತ್ತೆ
Senior, I'll start.
Yes.
Kindly note the.
Send someone to get him. Yes.
This Milord, the
Now, where is the order, sir?
annexure A Milords.
Annexure?
Kindly Milord, I'll just take note. Plaint Milord and the prayer. Page 111 Milords.
Page?
111. Annexure H. Kindly Milord, this plaintiff is concerned between the petitioner herein. There are number of suits and petitions are pending before various courts.
Between,
Yes.
all right.
In respect of Milord, the claiming of logo is concerned, one suit is filed in the year 2022. In that, my lord, when application is filed in respect of a jurisdiction, that, my lord, the went up to Supreme Court. Matter is pending before the Supreme Court.
Yes.
Kindly.
All right.
As of now, my lord, he files another one suit, my lord, before the civil court, claiming, my lord, 29 crore rupees of damages, and same is pending. In the simultaneous, my lord, in respect of the same cause of action, he files another suit, my lord, that is also pending, seeking injunction. Now, my lord, this suit is filed. In all the court cases, my lord, I am the party. I am contesting. In this case, my lord, his relief is in respect of intermediaries, social media intermediaries, not to allow them to post any of his postings or to allow him to broadcast his.
So whom?
The intermediaries.
Intermediaries. All
Yes,
right.
but the allegation is against me only.
Where is the plaint?
Page 111, annexure H. Kindly, my lord, starts from para 3 onwards to page 113 onwards. And, my lord, in prayer, kindly, my lord, page 117. It is, my lord, at page 118. Kindly, my lord, may I read, my lords. Restraining the defendants or any other persons claiming under them from providing platform to two dubious companies, Mr. Eagleside Telemedia Private Limited and BTV Kannada Private Limited, in posting or circulating programs. BTV Kannada Private Limited is specifically referred. In the entire pleading, my lord, everywhere there is an allegation saying that it is a dubious company of one particular person. And, my lord, when there is a pleading refers to a person or an entity, my lord, certainly, my lord, order 2, rule 3 will come into play. Then, my lord, he must make as a defendant. Deliberately, my lord, this plaintiff
yaru?
The plaintiff is Eagleside Media Private Limited.
Yes, sir.
This is, my lord, the first instance my submission. In other aspects is concerned, my lord, I have pleaded everything without suppressing any of the pending materials. And those suits which are filed, my lord,
What is the effect of this now? Restraint order is granted?
By virtue of this order,
Restraint order is granted.
It's completely, my lord, my platform is removed. Social media. It is completely blocked. That's why I'm before the court.
Yes, sir.
Please come to, let's page 61.
Yes.
That's the suit in which, if your lordship gets OS 584 of 2022.
Your restraint order pass ಮಾಡಿರೋದು ಇದ್ರಲ್ಲೇನಾ?
No.
This was another suit.
This is the principal suit in which, if your lordship sees, Eagleside Media Private Limited.
All right.
Versus defendant is Eagleside Telemedia Private Limited.
All right.
Then please turn over BTV Kannada Private Limited.
BTV?
Kannada Private Limited. All of them, lords, what happens is.
What is BTV got?
Your
BTV is it?
Eagleside.
And one of the director who was one of this BTV Kannada trademark, which is pending before the registrar.
All right.
Eagleside Media Private Limited is the owner of this BTV logos. Now, my lords, the director, one of the directors of this Eagleside Media Private Limited, lords, floated another company known as Eagleside Telemedia Private Limited. And, my lords, also BTV Kannada Private Limited. Now, on that, my lords, we filed a suit. In that suit, after consideration, an injunction was granted. Your lordship may kindly come to page number, my lords, this entire thing doesn't seem, but can I place a memo with the order, my lords?
That's all right, tell me.
So there is a, it's placed, is it? If, my lords, I am told the memo is placed, can your lordships kindly take that memo
Yeah,
with the
it's here.
2nd of May?
The 2525, it's here. Right?
The order, my lords, if your lordship kindly come to running page
Application
31.
ಇದೆ. In the court's order,
Oh, the trial court's order.
ಇದ್ರಲ್ಲಿ ಹಾಕಿಲ್ವಾ ಇವರು?
Adರಲ್ಲಿ, my lords, I think subject to correction. ಅದು
Where is it?
I have pleaded.
Where is the order?
ಇದು ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಹಾಕಲ್ಲ ಅವರು.
ಇಲ್ಲ. I have pleaded. I have not suppressed.
Pleaded ಅಂದ್ರೆ ಏನು?
I have not suppressed.
I am told it's filed along with a memo dated 2/5. Memo of documents by the respondent. Otherwise, I'll pass it on.
No memo filed here.
ಕೊಡಪ್ಪ. If it is not there, I'm sorry.
KVT ಇದೆ ಅಷ್ಟೇ.
May I just pass it on?
Now, which is the order under challenge?
Yes. No, that's the ex parte order.
Annexure A.
Annexure A is the present order. It's an ex parte injunction order. Please come to page 24. Dated. The suit number is wrong or what?
Where is your application? Application for stay.
Application for kindly.
For injunction, my lords.
Page
Injunction,
1.
sorry. Injunction.
For mine, look.
Lords, that your lordships will
Order
get.
39 rule
Page
1, 2.
122 is the prayer.
Let it complete.
No, because the court has.
ಹೌದು.
No,
ಆಯ್ತು, ಮಾಡಿ, ಮಾಡಿ.
ಅಲ್ಲಿ ನೀವು ಕೂತಿರಿ.
ಆಯ್ತಾಯ್ತು.
Court has said as sought.
Yes,
What was
120.
sought?
121 is the application. Please come to 121.
Where is the prayer?
121 application, 122.
120?
2. IA.
1 minute. So as sought is granted,
Yes,
right?
yes.
Yes, sir.
No, my lords, I was taking you that memo which I gave you. The lordships have. Please come to that. The first suit your lordships would get dated 5/9/22 order, my lords, at page 1.
5/9?
Our ಕೊಟ್ಟಿದ್ದಾರೆ copy.
ಹೇಳಿ.
Lords, in that I
Clear
was,
suit.
which is still pending.
Pending, all right.
I just showed the parties therein.
What is the order there?
There, the injunction granted, your lordships may come to running page 31. Accordingly, defendants, anybody claiming under them are hereby restrained from misusing, misrepresenting logos, contents, channel name, visuals, documents, office premises, studio premises, technical equipment, same employees and all other assets belonging to the plaintiff.
This has become final?
My lords, yes. I don't know, my learned friend, my lords, this injunction. Then please
According to
come,
it has become final?
please come to, my lords, according to me, please come to 37. This order was challenged in an MFA by BTV, my lords, running page 37.
I'm there.
That's an order dated 2nd of January,
Yes.
which the operative portion your lordships would get. Issues were framed, but please come to the operative portion at 78.
Appeal dismissed, SLP dismissed.
No, SLP is on, no, SLP is not against this. They
All
never went to SLP on this.
All right.
But please see at 78, appeals are dismissed. However, impugned order dated 5/9/22 passed by so and so in on IA 1 to 3 would be subject to ruling of trial court on its jurisdiction as per observations. That was, my lords, regarding whether that court has the territorial, the jurisdiction or the commercial court has the jurisdiction. That went forth here and there. Ultimately, the trial court had held that it has the jurisdiction to rule in. They filed a CRP, my lords, before this court challenging that order. This court held, my lords, that the court has no jurisdiction. The plaint was ordered to be returned, to be presented to the commercial court. We challenged that before the Honorable Supreme Court. That order is at page 80, where this Honorable Court's order of returning the plaint was stayed. The trial was directed to be continued, and my lords, final judgment not to be passed without leave. So injunction is operating so far as they are concerned. Now, my lords, apparently the logo of BTV and my lords, Eagle Sight is owned by Eagle Sight Media. That's a plaintiff.
That's a dispute still pending
But there is an injunction against them not to operate.
in that suit.
Yes, against them.
All right.
Now, my lords, what happened is, in respect of that, in spite of it, what they do is they go on using that logo and news items, BTV Kannada, in all social media and other channels. That's
What's the remedy for that?
Lords,
What's the remedy?
Lords, one is contempt. One is contempt. No doubt there is a contempt. That is one. The other one is an injunction, my lords, because the injunction order is restraining anyone. My lords, otherwise, my lords, what happens is contempt is for punishment. So I file a second suit seeking the restraint order so far as the intermediaries are concerned. Because, my lords, so far as BTV is concerned, admittedly, they are not the owners of, my lords, the
Intermediaries.
no, not the intermediate, the logos, my lords. If you allow.
That is a dispute still pending. Who has admitted?
My lords,
That's a dispute still pending.
lords, even the register, if your lordship
That's
kindly,
all. It has to be decided or not.
my lords,
Final decree ಆಗಿದೆಯಾ ಅದರಲ್ಲಿ? Decree ಆಗಿದೆಯಾ?
decree agila, but may I just place one more memo for the present, my lords. This memo.
No, I'm only.
All this is a part of the records. I'm just.
No, I'm only on the fact
Yes.
that so allegations against BTV galore.
Because it's my product.
Correct, sir. Galore in the application. In the application order 39 rule 1 or the plaint that is filed.
Yes.
Allegations galore.
Whether I should have made them a party.
Yes.
My lords, I'll only submit this. There is already an injunction operating against them in a suit in which their parties
So it
relating
was not
to the
necessary. It was not necessary.
Because, my lords, my prayer is these intermediaries are the ones who are permitting them. Their intermediaries are not parties in that suit. So they are anyway restrained.
That's the submission. Intermediaries are not
Parties in that suit. So against the intermediaries, I file a suit. Now, please come to this memo for a moment, my lords.
Which memo?
The additional memo which I just passed on.
ಏನಿದು?
My lords, this Eagle Sight Telemedia and BTV Kannada.
That is my suit ಅಲ್ಲಿ ಇದೆ ಅದಿನ್ನು. How are you
I'm only
wanting
saying-
me to pronounce something on
No,
this?
I am not. This, my lords, only this. It's an ex parte order. They are not parties. Ex parte order. Now, my lords, if they are aggrieved, they should first move the court below. Because intermediaries are not there, and there is a restraint order. Today, he can't come and say, I will violate the restraint order, but still, you can't get any injunction restraining me. Now, my lords, there are two judgments I'll only place. Only on this, and then I'll close it. Please see these two judgments. One is, my lords, the first one I would submit is on Wander versus Antox, which your lordships, I'm sure, would have seen it. On the principles of, my lords, appellate courts interfering in a discretionary order of a lower court in injunction. That judgment starts at 34, running page 34. In that, my lords, please come to para 14, which your lordships could get.